the states. Reading from my book here. Give me some states. Kentucky. Somebody just give me a state. What's up, everybody? What states are we from? What states are we from? What states are we from? Can I see the book again? You can see the book again. What states are we from? What states are we from? It may be backwards. Let me know if it's backwards. It may be backwards on YouTube. Let me see here. What states are we from, everybody? What states are we from? What states are we from? I'm reading from the 50 states in the book. Give me a state. Feed me a state. What's up, everybody? What states are we from? 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 This is a humiliation ritual. This is what this is. What states are we from? Let's see here. The Supreme Court of Arizona said that is Alaska. That is not Arizona. The Supreme Court of, where's Arizona? Arizona said, okay, evidence of a crime requires, you'll never believe it, injury. They said in Arizona, they call this thing causation. Causation is proof of injury. To gain standing in a criminal court in Arizona, a plaintiff must allege an injury. Somebody said they waiting on their book. Should be about one more week. Let's see. I gotta verify that I'm a human. What's up, everybody? What states are we from? What states are we from? What's up, everybody? What states are we from? North Carolina's in the house. New Jersey's in the house. Let's go. New Jersey. I forgot the name. Hold on. Give me 1 second. Yeah, you got about a week left. It ain't done printing. Somebody else, they got theirs. Everybody should have theirs, but North Carolina. There we go. Somebody getting theirs to Florida. Somebody getting theirs to Ohio. New Jersey. Let's see. What have the courts said in New Jersey? New Jersey. Nebraska. Nevada. New Hampshire. New Jersey. Hold on. I'm going to read this real quick. New Jersey used to be called Nova Scotia or something like that. Let me see if I can spell it right. Nova Caesarea. Nova Caesarea. That's what New Jersey stands for. I think it's Latin or Italian or something. Would you take $25 to scream as loud as you can? I would not. I'm sorry. I forgot I was on YouTube. What's up, YouTube? What states are we from? I am from one of the United States of America. Would you? Hey, ma'am. I'm not a ma'am. YouTube is wildin'. $25 to scream is like, I live in the hood. You can't just be screaming out here. They'll come. No, you can't just do that. $25 ain't gonna get the job done. Yeah, but New Jersey is called Nova Caesarea. Caesarea. All right, New Jersey, the Supreme Court of New Jersey said this thing called evidence of a crime embraces the occurrence of loss or injury. All right. So they said proof of evidence of a crime, this is the New Jersey Supreme Court, is the fact of injury as in the result of criminal agency. They said the proof of evidence of a crime required in all cases. How many cases? All cases is the occurrence of loss or injury. Somebody say loss or injury. They said in a criminal case, in all criminal cases in New Jersey, they said it requires injury. Yeah, that means the police officer can't just magically write tickets and say that you committed a crime. That's not evidence of a crime. What is evidence of a crime? The Supreme Court of New Jersey said evidence of a crime is the fact of injury. It's the fact that somebody had their rights taken from them, whether physically or to their property. That's what a crime is. It's not up for debate. What other states? What other states? They said this thing called evidence of a crime is supposed to be equal to all criminal cases. They said standing in Camden County. Where's Camden County? Camden County says standing requires harm. Nebraska's in the house. Let's go. Nebraska's in the house. Hold on, we're finna go to Nebraska next. Somebody said they from New York on YouTube. All right, where's New York? Nebraska. Hold on, let's go to Nebraska. What they said in Nebraska, everybody. You know Nebraska used to make their own passports? I made all the kids you leave on YouTube. You start talking about the law and crime. Yeah, they vanish real quick. They not asking $25 to scream as loud as you can no more, are they? In Nebraska, the Supreme Court of Nebraska said to establish standing in a court case, it is necessary to show direct injury. Somebody say injury, injury, injury. You have to show injury. You have to show it. You can't just write a ticket and say you committed a crime where there's no injured party. That's how you make the bots go away on YouTube. You just start talking about the Constitution, the common law of England. It's like roach spray. That's what it is. It's roach spray. Yeah, the Supreme Court of Nebraska not playing. They said in order to have standing in Nebraska, someone cannot rest his or her claims on the legal rights or interest of third parties. Who is that? That's the attorney. He can't rest. He can't be in court talking about, oh well, the paper said that he did this and she did that. Well, you can't testify on what you did not personally experience. So they said you got to have this thing called direct injury in Nebraska. That's what I'm talking about. What they call them in Nebraska? Corn huskies or something like that. Look at this. They say it again, standing. Say you got to have an actual controversy in Greta in the city of Gretna. You cannot rest your claims on the legal rights and interest of third parties. You have to have your own injury. That's what makes you a plaintiff in a court case. All right, somebody said New York. New York. What else? What other states? What other states? New York said standing in a criminal case begins with an injury. Ooh, they don't like that word, boy. They say injury, they'll hold you in contempt, won't they? They say, oh, you talk about injuries. No injured party. No, you're going to be held in contempt, buddy. We don't do no injuries here. The state was an injured party. They said a plaintiff has standing upon alleging an injury. There goes that standing. What is standing? Standing is legs in a court case. Okay? If you don't have the legs, the table called a jurisdiction cannot stand. All right? So they said a plaintiff has standing upon alleging an injury in fact, and they have to show the existence of an injury in New York. What's up, everybody? What states are we from? What states are we from? Feed me states. They said the Supreme Court of New York said the lack of an injury will be denied. Oh, now we know they don't do that. But they supposed to be denying them. Look, not the Supreme Court, but the criminal courts in New York said the service of an appearance ticket does not confer personal or subject matter jurisdiction. They said, yeah, this is not evidence of a crime. They said this is not evidence. A service or an appearance, that's what the police give you. He give you a service or an appearance ticket in New York. That's what they do. Well, here we go. Look at this. They said the judgment of conviction was contrary to the evidence adduced at the trial. The facts elicited were not sufficient. The authorities hold that a violation, even though it is deemed to be an infraction rather than a crime, must be proved of all its essential elements beyond a reasonable doubt. Somebody said Tennessee is in the house. What else? What other states? What other states? Tennessee. LMNOP, QRS. QRST, that's Texas. So that would be before Texas. Tennessee. They said in Tennessee, you have to establish beyond a reasonable doubt that a certain result has been produced. They said we must first address this issue of standing. This is the Supreme Court of Tennessee. Arizona's in the house on YouTube. We're going to get to Arizona next. All right. They said we must first address this issue of standing. What is standing? Standing is the legs of a court case. That's how the court case exists. They said we must first address the issue of standing. A court may and properly should refuse to entertain an action at the instance of one whose rights have not been involved or infringed. You could close the book right there and say, okay, well, did that police officer have his rights involved or infringed? No, he wrote a fake service appearance ticket, right? They said, it has been said that no case or controversy is presented where the plaintiff lacks standing to sue. They said the focus should be on whether the complaining party has alleged an injury. Somebody say alleged an injury, economic or otherwise. They said to establish standing, this is the Supreme Court of Tennessee, to establish standing in a court case, a party must demonstrate. They say you better be in there hopping. You better be falling off the crutches when you get in there. They say you must demonstrate that you have suffered an injury, and it must be distinct and palpable, not conjectural or hypothetical. That said the party must establish a causal connection between the injury and the conduct which he complains. Okay, not one police officer does that outside of an injured party. Not one state attorney can prove that that happened outside of an injured party. And then the prosecutor was not a witness, so they couldn't have been there to see the issue in the first place. And then they also break the law because they didn't receive a complaint from a plaintiff. They received a citation, which is not evidence of a crime. They said these elements are indispensable to the plaintiff's case. Oh, Arizona. Almost left Arizona in the wind, boy. All right, well, you'll never guess what they say. They said this thing called evidence of a crime requires the element of injury. And then they have to have a criminal that committed the injury. Because how do we know the injury wasn't an accident? Right? There has to be criminal causation to this thing we call a crime. Right? Because a crime, what separates a criminal action from a civil action, right? Okay, not just the injury, but that the injury was intended to injure or harm or damage or take something that did not belong to them, right? That's versus an accident. An accident still causes a court case and it's legitimate, but intent, something that is inherently wrong, that you knew you were not supposed to do, right? So that's Arizona. Arizona said the state must prove evidence of a crime. They said, we denied standing to citizens seeking relief against the governor because they failed to plead and prove palpable injury. This is the Supreme Court of Arizona. I guess they was beefing with the governor. They said in another case, okay, to have standing, there's that word again, standing. Standing, how do you stand? You stand with two legs, right? Okay, well, a table has four at least. Well, it depends on how the table stands, but you still got to have some legs. All right, in order to have legs in a criminal case, somebody has to allege injury. A police officer cannot allege injury. He can take a statement, he can take a complaint, he can receive one, he cannot create one. And a state attorney did not receive one. They made briefs. They made an argument based on a citation. They never received evidence for a crime. This is very important, right? So they said, this is the Supreme Court of Arizona. They said you have to allege an injury. You can't just hand somebody a ticket and say, oh, well, you can pay it, or you can go try to fight the magistrate over it. Okay, that's not a criminal action. What states? Give me some states. What states are we in? What's up, everybody? What states? Arizona. We just read Arizona, Arizona. I'm sorry, Arizona. Georgia. Georgia's in the house. What is crime in possession? What is the crime in possession? That is the question. That's what I would ask. That's what I would ask the prosecutor. What is a crime in possession? Here, let me tell you. The Supreme Court of New York tells us this. Nebraska, New Hampshire, New York. Okay, the Supreme Court of New York said they cite the New York Constitution. They said all men, we hold these truths to be self-evident. All men are created equal and they are endowed by their creator with certain unalienable rights, right? They said a crime, this is the New York Supreme Court, a crime is an act committed by an individual which injures person or property within a victim's personal freedom. Somebody say victim. They said mere legislative fiat cannot take the place of a fact. What is legislative fiat? Faith that the statute is real. They said the ultimate fact to be established here is a legal possession of an arm, right? They said, well, there is no actual proof of illegal possession. They said evidence of a crime must be proved. They said possession is not proved. It is presumed. This is a nasty case. They said this thing called the legislator has no power to declare one guilty of a crime just because they wrote something is a crime. They don't have the power to do that either. They do it, but they don't have the power to do it. They said the legislator doesn't have power to declare one guilty of a crime. They said that is the function of the court after proof. They said it is unconstitutional for the legislator to presume guilt of the accused. There is nothing against which to defend because no crime has been proved. So that is a great question. What is the crime of possession? Well, crime always requires a victim, according to the New York Supreme Court. They said a crime is an act committed by an individual which injures person or property within a victim's personal freedom. Okay, well, don't say I committed a crime when there was no victim's personal freedom injured. Somebody said Arizona, Georgia, Georgia. Georgia, that is Oklahoma. Georgia would be at the beginning. Maine, Louisiana. Florida. Nope, Florida should have been right after Georgia. Delaware, Florida, Georgia. All right. Yada. Here we go. The Supreme Court of Georgia. I'm trying to see where the case starts. They said when the United States, this is the Supreme Court of Georgia. They said when the Supreme Court determined that an irreducible constitutional minimum that a plaintiff who invokes the court's jurisdiction must allege that he suffered an injury in fact. There we go. That we could close the book right there. Supreme Court of Georgia said that. The United States Supreme Court said if you can't go into the federal courts without alleging an injury, well, you can't come into the Georgia courts without alleging an injury. They said this is the irreducible constitutional minimum. They said this is what you have to have. Remember, we got this thing called standing. They said these are the legs of the court case. It can't stand without it. They said a plaintiff who invokes the court's jurisdiction must allege, okay, the police officer didn't do that, the state attorney didn't do that, the prosecutor didn't do that. You see how unfair that is? Where the police officer who works for the government, the state attorney who works for the government, the prosecutor who works for the government, and they all present you to a magistrate who works for the government. It's a 4 against 1. No injured party, no real case. They just said, we want some bread. This is how we're going to do it. They said this is the constitutional minimum, that you have to allege that you suffered an injury. They said an evasion of a legally protected interest, which is concrete and particularized, actual or imminent, not conjectural or hypothetical. So they said in Georgia, okay, nothing changed. They said a plaintiff must show that he personally has suffered some actual or threatened injury. You see how crazy that is? They get away with it every day. They say, oh, well, we don't. Go Google it. Google what a crime is. They're going to say a crime is a violation of a criminal statute. Call an attorney on Monday. They go ask them, what is a crime? I just want to know the definition real quick. I'm about to start law school. What's a crime? Oh, they're going to say, oh, yeah, buddy, a crime is a violation of a criminal statute. And you'll find it in the whatever state you're in. The Tennessee Code will tell you that. Okay, the Tennessee Code is not the law, so they can't tell you that. And an attorney also can't tell you that because attorneys are not in the state constitution. They're not in the federal constitution either. So the Georgia Supreme Court said, yeah, a plaintiff, that should always be in your mind. Okay, well, who's the plaintiff? What is a plaintiff? Let me pull up a law dictionary here. We're going to look up the word plaintiff. I'm going to put it on the screen. I pulled up the wrong dictionary. Well, sorry, YouTube, I can't put it on that screen, but what is a plaintiff? Oh, that's the letter V. What is a plaintiff? What's up, everybody? How you doing? How you feeling? How you living? It's Sunday. We're not watching no Super Bowl, are we? We don't support merchants. We don't support the merchants. The kids are making fun of it. They say, we know who wins. Israel. Israel's the one who's winning the Super Bowl tonight. You know it's getting bad when the kids are like making memes about it. Their kids are like making TikToks about it. Like kids, like regular like teenagers are making fun of it now. They know it's all a joke. All right, what is a plaintiff? A plaintiff, a plaintiff. Plaintiff. Nope, that's the letter E. P, pledge, pleading, pleading. Here we go. Plea, plain. Dang, they got a lot of pleas. Place, pirate. Nope. Plaintiff. Oh, here we go. Beautiful, beautiful. Let me see if I can highlight it. I'm gonna put it on the screen. Beautiful, beautiful. Look at this beautiful bean footage. A plaintiff. He who in a personal action seeks a remedy for an injury to his personal rights, everybody. Look at this. Look at this. What is a plaintiff? They'll look you dead in your face and say the state of is the plaintiff. No, that's not the definition, sweetie. You know that. Here we go. Let's put it on the screen. I'm going to put it on the screen. They said this is the definition. They said also see the definition of parties to an action. They create a court action every day with no plaintiff. They have no plaintiff ever. Oh, I forgot this is above my head. Hold on, let me remove this. And then we'll add. Oh crap. Gotta put it in the right folder. Gotta put it in the right folder. All right, and then we're gonna put it in the folder. There we go. Don't be forgetting, this computer stuff is trash. All right, here we go. What's a plaintiff, everybody? Y'all see that? Boom. What's a plaintiff? He who in a personal action seeks a remedy for an injury to his rights. They got 1 law book, 2 law book, 3 law books, 4 law books that say the exact same thing. So as a defendant, how do I get standing so that I can introduce the argument that there has been no injury? Well, you don't have standing as a defendant. So first we got to realize how a court case gets created. You got a court case created on you where there was no injured party because you have a state ID or you were driving a car that they have information on. As a result, you only have so many options. And I don't give legal advice. I'm not an attorney, but depending on the time frame of when this supposed action was created, you need to because this has been created in the system, you can try to do a bill of particulars. You can try to, these are things that you may not even know exist. Try to do a bill of particulars from that specific courthouse. You need to know the court rules on how to get things done. See, we all, and I'm not shaming, I'm not judging, but we always want help after we gotten in trouble. And then somebody gives you advice and we're not prepared to do these things because we only care about the law when it's against us, right? How do we get the court rules? You could go to the court should have a website. If not, you could go to the actual court building and ask the clerk of court. You probably have to pay for it, but they should have a book or a pamphlet or something that has the court rules, how to file things, or some like this bill of particulars. It depends on the court. So some courts, they have a document. You just fill out that document called a bill of particulars, or you may have to create your own document called a bill of particulars, get it notarized, and then send it in to the prosecutor, because that's the one who is who created the case against you. The police officer didn't technically create the case. They just created a citation. And that citation went to the prosecutor. The prosecutor created this case by way of an information, no evidence. And then they gave that to this person called the state attorney. And then I don't know how this works ultimately, but if you make it to the arraignment, okay, well, 9 times out of 10, you're just going to be dealing with the magistrate. You may not see the state attorney there because that state magistrate only wants a plea. See, they railroad you on every instance, right? And then we say, how do we get out of it? Well, we got sometimes, depending on the punishment, you may just need to take the L and start learning the law. Because some scammers gonna say all you need to do. No, that's why I can't give you legal advice, because I don't know you. I don't know all the facts of your case. And then I don't know your particular court and how they do things. Every court is allowed to have their own rules on how they do things. So that would be the first thing. Like, this is perfect information if you're not in trouble. Right? If you stay ready, you don't have to get ready. Right? So if you move to a new town, like, okay, give you a little personal information. I'm moving to Florida this week. Okay, well, the first thing I'm doing is I'm going to the courthouse. I don't have no court cases. I'm not in legal trouble that I know of. There could be things happening behind the scene, but there are no legal issues that I know of. And so I'm going to go to the nearest court. I'm going to go to the district court, and I'm going to go to the county court. I'm going to get the rules of the court. I'm going to get every available piece of information that I feel I need to know about, so that if I stay ready, I don't have to get ready. Does that make sense? So if somebody wants to try to create a fake case on me, okay, well, I'm already ready. I already know what I need to do. Boom. I know who needs to be addressed, right? I need to know everybody's name in this county. I want to know who the county prosecutor is. I want to know who's on the city council. I want to know who all the magistrates are in the county. See, these are our responsibility. Right? We don't want to talk about, oh, well, we're really sovereign, and then I ask you about your state, your history, and all that stuff, and you can't tell me none of it. Okay, so worst case, in Arizona, you need to get a trial by jury. Worst case, which is the best case, but the worst case, if they called it a crime, you're entitled by the Arizona Constitution to a common law trial by jury. All right. And then you explain all of the foolishness that has happened, that the government cannot be the plaintiff and then be the judge where there is no injured party. Why? Because the purpose of government is to secure rights. Right? So you need to get the rules of the court and figure out how to get a trial by jury. They may have a paper. You may need to submit a paper. Right? So all of these things are important. So you're going to explain to them that, okay, well, the Arizona Supreme Court said, what they said, the elements of evidence of a crime is injury by a criminal. Okay, you're going to explain that to the jury. And that a crime is established by showing proof. The Arizona Supreme Court said. They said we denied to the citizens of Arizona seeking relief against the governor because they failed to plead and prove a palpable injury. Okay, well, that state attorney over there with no injured party next to them failed to plead and prove a palpable injury because she or he doesn't have the power to create a court case and have standing against the people that she is supposed to be protecting. Right? So that's what I would do. Not legal advice, again. So how do you defend yourself? Well, depending on the time length and the circumstance, people always want to come to me like 1 week before they got a court case. I'm like, bro, that's the kids say you're cooked. You're cooked. Sorry. All right. See, and I'm nobody's judge, but we supposed to know this stuff way before something happens. right? And we don't care until it's too late. I heard a rapper say, I used to think it's because we ain't know. Now I know it's because we don't care. I said, oh, well, there you go. Yeah, we don't care nothing about the common law or the Constitution until after the government done took away your rights. It's like, oh, well. And you got 1 week before the court case. And you ain't got no evidence. You don't have nothing. You don't know. Yeah, until they put you in handcuffs. I'm like, okay, well, now you want the common law of England. No, you don't want the common law of England when you was driving. When you purchased that car and they took that information to the DMV and registered it behind your back. You didn't care about the common law then, did you? And again, I'm not your judge. I'm not your enemy. I'm not the bad guy here. You know what I mean? I'm just saying I had to learn this too. When I first learned this stuff, I got tickets and I was in the back of my head, I was like, oh, I'm gonna explain to him that he doesn't the police over yet and then something said, you probably should shut up. You probably should keep your mouth shut. You probably don't know half of what you're talking about, and he probably don't want to hear what you got to say. And you're gonna end up on the news on the newspaper talking about, and they're gonna say, oh, this sovereign citizen thought he didn't know how to obey laws. I said, yeah, you know what? You probably should shut your mouth right now. You probably should just hand him that driver's license that you really got in your back pocket. And that real registration you got. Yeah. Yeah. People will learn something brand new and think they figured it all out. No. I'm on like year 7 now. Okay. And I don't have a car and I don't have a state ID now. And I walk everywhere. So uh so now I can talk all the trash I want. But I could not talk trash when I was driving cars and they can pull me over, right? So um, when they tell me a jury trial, is that different from a trial by jury? Probably, but that's the best hope you got. You got to explain it to the jury. But that's what happens when we don't know what a jury is, right? Who are the judges of Arizona? What else? What other states we got? What other states we got? Give me some states. Give me some states. Go read the court rules. Go read the court rules. Court rules are not the law, but it will tell you how to respond with the law. Colorado's in the house. Colorado. Who's that? California, Colorado. What is evidence of a crime? Evidence of a crime requires. What does it require? It requires an injury. It's real simple. The Supreme Court of Colorado said, yeah, this thing called evidence of a crime. See, they can write whatever. They gonna write whatever. They write whatever. They do it. We don't have to, it's not up for debate. They write whatever they want. But they can't admit everything that they want. Well, first of all, they don't admit it. They don't have evidence for a crime where there's no injured party. So they said, oh, well, again, what do they hand you? They hand you this thing called a citation. That's what the police officer hands you. He hands you a citation with a statute on it. Okay, well, that's not evidence of a crime. We're finna look it up. What is a citation? And all you're asking for is the evidence. What is a citation? Okay, that is not it. Citation, a citation, a citation, a citation, 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 citation. So y'all need to get this book and then you need to highlight. I need to highlight. Well, I know what a citation is. I just want to prove it to you. Citation, a citation, a citation, a citation. Oh, capias, a capias. Here we go. A citation. Here we go. Let's see. All right. A citation is a summons. A summons. A summons to appear. What book am I referencing? I'm referencing my book. It's called The Discernment of the Vigil. Understanding the Courts. They said a citation is a summons. Okay, that's not evidence. They said a summons to appear in a spiritual court. They said ecclesiastical courts proceed according to the course of civil and canon laws by citation. So the question isn't jurisdiction. They have jurisdiction. If they could create the case, it's because somebody went to the DMV and asked for a state ID. Jurisdiction is not the argument here. The argument is standing. They created the case. You can't say they didn't create the case. What is jurisdiction? Jurisdiction is the power of a court to hear and decide a case. Jurisdiction is just power to hear it. Well, how can they hear it? Because they could create it. How did they create the case? Okay, a civil case, which is really what this is a contract. When you went and got a state ID, you said, I want to be bound by the motor vehicle code, which is subject to international commerce. And when you said, I would like a state ID, or when you went to the car dealership and said, I would like a car. Okay, well, they said, well, dealership is a maritime term. I can't wait till I get that maritime book done. If I get that Admiralty book done, oh, that book gonna be so nasty. Yeah, what's a dealership? Y'all know what a dealership is? Yeah, it's a maritime term. See, when we think we don't give them jurisdiction, but everything we do is jurisdiction. We swear we didn't give them a jurisdiction. Yeah, what's a deal? Sorry. A deal is the root word of, it's not presumed. They proved it. You went to the DMV. Don't say you didn't go to the DMV. They know who you are. How did they know who you were? Jurisdiction means they have power or they don't have power. There were circumstances in my life where they knew exactly who I was. They knew where I was born. They knew where I lived. Okay, well, where'd they get that information? They got it from me. I gave it to them. I didn't read no Constitution. I didn't know no common law. No common law of England. When you show up on the computer, that's how they create the case. Don't you know that the cap's name is not you? Mm-hmm. Yeah. Again, try to explain that to them. Either you show up on the computer or you don't show up on the computer. That's it. So what's a deal? When you go to the dealership, what are you doing? They said a deal in nautical and woodworking context refers to the plank of timber, specifically softwood from pine or spruce. Historically, this durable wood was a maritime commodity used to construct various parts of a ship. They said since you could not provide for yourself a method of getting from point A to point B, well, you came down to this thing called a dealership. And by participating in dealership, okay, well, they kept this ship called commerce alive. Because when you obtained that automobile with Federal Reserve notes, that established a contract. And the contract was that this dealership is going to give the information regarding that vessel over to the DMV. And that's what they did. Because people who show up on the computer have given the courts jurisdiction over whatever case arises within the subject matter. Well, it's time to start blocking the feds. Everybody say bye-bye, fortunes of the chosen. Bye-bye. They always got something to share in my comment section. They don't never make their own videos on this stuff. They say, no, you just really don't understand that you were considered 3/4 of a man and then labeled black. That ain't got nothing to do with me going to the dealership. That ain't got nothing to do with me going to, they arrest white people too. This is not about skin color. Since the Civil War, all who participate in commerce get to assume the title of slave. This isn't based on pigment or skin color. Right? So They said, yeah, when you went to the dealership, you helped construct parts of a ship. Okay, that ship, all ships are maritimes. Who is the injured party in a drug case? You need to ask the jury that. You need to ask the prosecutor that. You need to ask the state attorney that. We just read there is no such thing as a crime where there is no injured party. That's what you need to be asking. I don't know you. I can't answer that for you. The Supreme Court said there's no such thing as a crime where there is no, the Supreme Court of Arizona said there's no such thing as a crime where there is no injured party. So I don't know who the injured party in a drug case is either. But I'm not the one in the circumstance, so I couldn't answer that for you. Right? Why is the jury significant? They deal with each individual case. I can tell you this stuff all day. But the jury decides. The jury is the sovereignty of the state. They are the sovereignty of Arizona. And if we haven't done our due diligence in informing our community, informing our counties on what the law is and what the law is not, okay, well, these little Supreme Court cases don't mean anything. Because by the time it makes it to the jury, whatever their conscience has been led to be determines what the law is. People tell me all the time, brother, well, I went before a racist jury. Okay, well, again, we still don't know how cases get created. When you went and got that state ID and you said, I would like a driver's license, and they said, okay, we need you to fill out all these papers. We need you to take a test. We want you to take a driver test. Then we want you to take a computer test. Then we want your photograph. They say some states they take your fingerprints, and they want a social security number now. They want a birth certificate. They want all of these things. Then they want some Federal Reserve notes. They say, and that'll be $100. Thank you very much. Okay, we didn't ask not one question. We didn't ask what the law was on this. We didn't ask what the Constitution says. We didn't ask what the common law of England was. We didn't due process. It wasn't no due process. They gave you due process. They made you wait 3 hours in line at the DMV. They made you wait 3 hours. Nobody has ever had an amazing DMV experience. They say, yeah, that was due process. Nobody told you to come here. That's why I get in trouble. Because Lord forbid I don't get in trouble by the government, but I will definitely get in trouble with y'all. Because we don't like to admit, well, we did this. We did this in ignorance. Our parents did not teach us. Our grandparents didn't teach us. And we blindly believe what people told us to do without questioning. Sure, but fraudulent doesn't stop the court case from being created. I'm not your enemy. I know it's fraud. That don't stop the court case from being created. And why didn't your parents tell you? Why didn't your grandparents teach you about the common law and the Constitution? Why didn't you read the Constitution and ask, was this the law? Why didn't you consider your rights before you started signing up for things without asking these questions? We always want to say, oh, the government, oh, the government. But we never look in the mirror and say, you know what? I didn't read not one Constitution, Bill of Rights, none of that. You didn't read it. And then we don't care until we're in trouble. I get on here every day and just I talk about the common law every day now. And people could give two craps about the common law until they got a court case created about them. Yeah, you know that now because you done got in trouble over it. But if you'd have read your Bible like this country was founded on, you would have known not to participate in commerce. So we don't want to hear fake commercial arguments about contracts and all that stuff. You signed. You went to the DMV and you only complain when you get in trouble. See, I learned this information and I wasn't in no trouble. And I said, oh, I got to rearrange my life. I really didn't believe it until I saw those Amish people. I said, oh, that's what life looks like. That's what the common law looks like. Those Amish people. Yeah, because they don't have none of that birth certificate or social security cards or driver's licenses and state IDs. They don't have cars either. They don't even have electricity. They got a horse and buggy. Or they pay somebody. They don't have banks either. No banks. No lie. I was in Ohio and the dude I was riding with to a job, he said his homeboy used to beat up Amish people because he knew they didn't have banks. I probably can't say that on the internet, but but that is true. He said they don't have banks. I'm talking about I didn't tell this dude I was studying the law or the common law, none of that. We saw Amish people and I was so amazed that he started telling me all these things. And I was like, well, that sounds like the stuff these people be complaining about on the internet. These people don't have banks. They don't go to grocery stores. They don't have cars. They don't have birth certificates because I asked them. I asked these Amish people that I saw, well, do y'all have birth certificates? Do y'all have social security cards? They said no. And they went walking up the hill outside of the Steak and Shake. I said, oh, well, they don't talk about those Amish people, do they? Yeah, guess what? The Amish people don't have to pay every April 15th. Yeah. Look like somebody lied to us, huh? Okay, well, guess what? You couldn't make it. Somebody tried to, and this is not shame. Somebody asked me on Patreon, they were like, well, I'm from Virginia, and they said they wouldn't let me return a state ID. And I said, you know what? They probably right. Could you make it without the system tomorrow? Do you have the necessary skills to hunt, to eat, to build a log cabin, to fish, to clean water, to preserve food, to make clothes, to clean clothes with no washer machine? Okay, yeah, you probably should keep that state ID until you learn a little bit more of the law. Because if you go return that state ID tomorrow, you will not be able to get a job if you do not know the law. If you don't have any skills that somebody are willing to pay for. You know how those Amish people make it? They build log cabins. They can build a log cabin and they can build a house, not a log cabin. They can build a house in 3 days. A house. They say it'll take a month, 1 month for a 2-story house. Okay, they have real skills. They don't need no. And they've been here since one group of people came before the Revolutionary War. One group of people came after the Revolutionary War. They said they had them same skills before the Civil War, and they've kept it all the way to 2026. They kept that knowledge and they passed it down from generation to generation. And now we got people complaining about how the government's treating them. They don't hardly complain ever. We don't even know they exist if you ain't been up in there. If you ain't been in the Northeast, you don't even know they exist. I live in the hood, y'all. My neighbors be cussing and arguing all day. But these Amish people don't deal with that. When they deal with the system, they really deal with government oppression. They really deal with it. What we complain about, we signed up for. And then want to talk about the common law. No, we don't care about no common law. We don't care about the Constitution. We want to watch the Super Bowl tonight. And we want to see all the cool commercials. We want commerce. We want to be free from the system and participate in it. No, you don't get to have both. Either you're free or you're acting like you're free. But when you go up in the woods of Pennsylvania, you go up in the woods of Ohio, you go up in the woods of West Virginia, you go up in the woods of New York State. Okay, well, they don't have no electricity. See, we just had a snowstorm here in the South, and okay, well, half my town was out of power. Okay, well, that wouldn't have been a problem for the Amish here. If there were Amish here in the South, they say there are some, but not a lot. But that wouldn't have been an issue. Why? They know how to create this thing called a fire. They know how to build a log cabin with no electricity, with no nails, and it survives all the winters. Okay, well, we complain about fictitious fake contracts and how the government did us wrong. They say you can leave whenever you want. Oh, but you got to be able to make it. You can't keep coming back into the system talking about some, oh, I'm sovereign. Yeah, they don't want to hear that. That's why these people be on YouTube getting their windows broke out. Talking about they super sovereign and they declared their stat. Yeah, the Amish people don't have no status. They mind their business. They knew the law and they passed it down. They racist, but good for them. They get to be racist and don't nobody bother them. So what? They don't create injured parties. Exactly. They hire somebody to drive them around. I told y'all I was working on a water drilling rig in Miami, and these jokers got off a tour bus, the Amish. Like it was a rap video. They came off with the little house on the prairie off a tour bus in Miami. I said, what is this? Yeah. They pay people to go where they want. They said, we want to see what Miami like. No lie. I worked the night shift on the drilling rig. We got off. We went to eat breakfast before we went to sleep, and these jokers got off the tour bus. Or a charter bus, not a tour bus. It's the same thing, but they got off, ate breakfast with them. I said, no way. They said they were from Ohio. I said, no way. Right? Because they know the law. They know that stuff will create a contract. So this is what we ignore. Well, those people, half of them came from England, half of them came from Germany. Well, they were fleeing in their day, right before the Revolutionary War. They were fleeing these people called the Red Shields. Okay, well, these Red Shields showed up and started handing out commercial paper, and they would exchange people's paper or that paper for people's property or for people's gold and for people's children. And they would establish these fake commercial contracts. Okay, well, they knew that when they got here. They were fleeing that stuff in ancient. Well, that's because nobody else is commenting. They don't show my stuff to people on YouTube. Welcome to Constitution Academy. He said, "How come I'm not seeing nobody's comments?" That's because they don't comment and they don't show it. This is what censorship looks like, everybody. Welcome to America, right? But let somebody. I've seen the most flagrant, vagrant, disrespectful stuff on this platform, but if I say two words in the proper context, they'll shut down my live stream. Right? Because you can't tell the truth. This is not for the truth, right? But I forgot what I was talking about. Yeah, the Amish. There's something like that. Something about the Amish. I don't forgot. What other states? What states are we from? That was good too. I was ranting and rambling. I'm gonna put all that on YouTube in a week. What other states? Tennessee. I thought we read Tennessee already. Yeah, we read Tennessee. Give me somebody else. Give me some more states. Somebody did. They did have some states on here. They're talking about all fraudulent. Mm-hmm. I bet $10 he got a state ID in his back pocket. Talking about all fraudulent. Yeah. Y'all say anything on this internet. Jurisdiction is the foundation of all legal claims. No, it's not. Colorado. Oh, we were reading Colorado. I had Colorado up here, didn't I? Colorado. They said evidence of a crime, and the Supreme Court of Colorado said the evidence of a crime consists of injury and unlawful conduct causing that injury, right? Because that would be the difference between an accident and a crime, right? Both can create a court case, but one they can label a crime, the other they can't label a crime. You still may be liable, but one they can put you in handcuffs over, the other they can't put you in handcuffs over. Well, depending on the case. It depends on the case. Give it to the jury. I'm just kidding. All right. Iowa, Oklahoma, 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 Massachusetts, Minnesota, Montana, Nebraska. New Jersey. Oh, it's a lot of N's. It's a lot of N's. North Carolina, golly. Ohio, where's Oklahoma? Oklahoma said, at minimum, the bare minimum. This is the we give it a little glance. They said standing is injury in fact. They said we need an injury, everybody. Somebody say injury in the comment section. Injury. They said standing in a court case requires injury. And they said an injury which is actual, concrete, and not conjectural. Conjectural. Conjectural mean made up. It mean fake. That's what they do every day. Attorney get on here and say, oh, well, it doesn't require an injured party. Well, that's because y'all don't care about people. That's why I don't require an injured party. They said standing is not a decision on the merits. They said it is a determination whether the plaintiff is the proper party seeking adjudication. That's the Supreme Court of Oklahoma. They said again, this thing at minimum requires standing, or that minimum standing contains injury, and injury and conduct complained of. Okay, well, what's a plaintiff? Oh, I got it above my head. I forgot. See, I don't see what y'all see. Yeah, what's a plaintiff, y'all? Okay, well, they can't create a court. They do it. They do it because we participate in it. But you can't be creating a court case talking about the state was an injured party. Well, the supposed state of Oklahoma don't have a personal action that seeks a remedy for the injury to its rights. Because again, remember, the police officer, the state attorney, the prosecutor, and then the magistrate can't all be against you in a court case. That's called unfair. That's called a violation of the separation of powers. The purpose of government is to secure rights, not write fake statutes that take them away. Florida, 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 Florida. Are y'all learning anything? Are y'all learning anything? Florida said, okay, yeah. Okay, they got this thing called causation in Florida. Causation. Can I have my attorney ask the magistrate to instruct the jury? No, you can't do that. No, the whole sentence is wrong. Yeah, you don't get to have an attorney and have rights. You can have one or the other. Remember, there's no attorney in the Arizona Constitution. If you want rights, you're going to have to learn the law and fight for them yourself. They said causation consists of two distinct elements. This is Florida, Supreme Court of Florida. They said before a defendant can be convicted of a crime, a defendant's conduct must show cause and fact of a particular harm. They said they have to have legal right of a plaintiff against the defendant together with a definite violation of loss or damage. I told y'all this story. This dude in Florida got this book. He read this before the magistrate and they dismissed this case. Because I think, and I could be wrong about this, in Florida, well, this may be in every state, I don't know. And when you go to traffic court, they do it like a drive-through. It's an arraignment. They just say, how do you plead? No contest, guilty, not guilty, right? Everybody plead no contest. Okay, well, that's all they want. But this dude went before the magistrate and read these cases in front of everybody. They said, case dismissed, get him out of here. Who let this guy in here? He messing up the gravy train. Because remember, it's not about injury. They tell you, call an attorney tomorrow and ask them what's the definition of a crime. They gonna say it's the violation of a criminal statute. Okay, well, they're not there over injured parties. They over there to get that bread. Okay, they over here. They trying to go to Ruth Chris this weekend. All right, they finna get bread. And so they said, yeah, you can't. The court rules. The court rules. Somebody say it to them on YouTube. The court rules. I told you this. You got to read the court rules. You got to go to that court. You got to know the court rules. Every court is different. I can't give you legal advice because I don't know what county. I don't know the court. I don't know the rules of that court. You have to know the court rules. You have to know your state's constitution as well. None of this stuff happens overnight. So Florida said, the fundamental principle of law that no one can be adjudged guilty of a crime until the state has shown that a crime has been committed. Sounds good. Sounds good. They said the state must show that a harm has been suffered. Okay, that police officer can't show that. The state attorney can't show it. The prosecutor can't show it. And then they gonna present you to the magistrate. Say that's unfair. They said the state must show that a harm has been suffered, a death, a loss of property, or that such harm was occurred. This requires the victim of a crime. Oh, yeah, if he read that in there, yeah, they'd have kicked him out. Yeah, get out my courtroom, sir. Who told you you could read that? Where'd you get those cases from? They don't know you be reading cases, boy. You got to read these cases. These cases nasty, right? Because I told you, they write whatever they want, but they can't prove whatever they say. That's the issue. They say, oh, well, we wrote it. It's a violation of a criminal statute. Well, there's no such thing as a criminal statute. I got a case concerning the common law. They said, well, the legislator and Congress can prescribe punishment for perjury, murder, whatever the offenses are in the Constitution, but they cannot define those things. They said to define all of this stuff, you have to go to this thing called the common law of England. They said the legislator can't define things. These attorneys will look you dead in your face and say, oh, well, the legislator defines the crime. No, you don't have the power to define. It's already been defined. That's why we created this thing called the Constitution. It tells you. You can't interpret your state constitution without reference to the common law, right? So they said, yeah, you have to have loss, harm. This requires a victim. Okay, well, the state can't be a victim and then be the judge. You know how crazy that is? They do it every day. They say, oh, well, the state is the injured party. And then they're going to let the state be the judge, too. Say corruption. Corruption. All right. Florida, Michigan, Iowa. Ooh, Iowa's in the house. Let's go. Iowa. See, isn't this funner than the Super Bowl? They said, no, it is not. Iowa. Hawaii, Idaho, Illinois, Indiana, Iowa. All right. They said to have standing in the Supreme Court of Iowa, a complaining party, there we go, that's what a plaintiff is, must be injuriously affected. Injuriously affected. What else? Somebody said Texas, Michigan. Let me see. Who is this? Iowa? That's what I was saying. They said the courts are instituted to afford relief to persons whose rights have been invaded. That police officer's rights were not invaded when he pulled you over. Talking about you ran a red light. And then he gonna hand you a ticket, a citation that says, okay, well, you can go ahead and pay it, or you can go to court and try to fight it in front of the magistrate. That's called railroading you. They say either you pay, if you pay it, they're gonna call it guilty and it's look like a win for them. If you go in court, they're gonna make you look like you're a conspiracy theorist, sovereign citizen, and they don't do the common law there. It's a win-win. It's a slam dunk, baby. They said the courts are supposed to be instituted to afford relief to persons who have their rights invaded. What was it? Iowa's nasty now. Look at Iowa. They said the language of the statute requires other proof, not the statute. The statute is not proof. That's what they say. They say, oh, well, you broke the law. You got to take it up. You need to vote for better people. What? Vote for better people? That's not a crime, sir. They make it seem like it's all your fault. Oh, well, you voted for this guy. No, you weren't allowed to do it no matter who was in office. You weren't allowed to call this a crime no matter who was there. They said, okay, well, the language of the statute requires other proof as evidence of a crime. They said this doctrine might involve some or all of the elements. First, they said the first thing we need is harm or injury. They said the criminal origin, the origin of a crime, is harm or injury. They said before we even get the party jumping, we got to have those two things. Now they do it without it. We know that, but that's what they're supposed to have. They said most courts hold that the requirement embraces the first element, which is harm or injury. Okay. Michigan. Maryland, Massachusetts, Minnesota, Missouri. I feel like I'm missing Michigan. Should have been way back there. Yeah, I feel like Michigan was before all of those. All right, we got Maine. Yeah, this is on my book, by the way. Constitutionacademy.org. Understanding the court. I got all 50 states in here. I got all 50 states. You just read them in front of the magistrate or read them in front of the jury. Good luck. No lie, 5 people said they got cases dismissed. 3 people from Texas, 1 person from Florida, and I actually forgot the other state, but I believe it was in the South somewhere, maybe Tennessee. But they read them. They read them in front of a magistrate, so good luck. But this is the law. I'm not making these not fake things. These are real cases. You can verify everything in this book has a citation. I tell you exactly where I get all my information from. But I did the homework, so you got to just like you pay the nerd in school, you got to pay the nerd. All right. Where are we going? Michigan? I still can't find Michigan. What if I don't have Michigan in here? All right, Maine, Maryland, Massachusetts, Michigan. All right, you'll never believe it. You'll never believe it. The Supreme Court of Michigan said, yeah, evidence of a crime means the body or substance of a crime. They said this thing requires injury and some person's conduct causing the injury. Yada, yada, yada. They said the Supreme Court of Michigan said a defendant's acts must have caused harm. That's who they think you are. They think you're the defendant. Okay, well, can you show me where I caused harm? Oh, they said, oh, a crime doesn't require an injured party. Okay, well, case dismissed then. Baby. They said, Supreme Court of Michigan said, well, this thing that constitutes a crime is pursued by an injured party. Uh-oh. I thought you said it didn't require one. They're going to hold you in contempt. You better be nice in there. They're going to hold you in contempt. They don't like when you show up with the law. They said this thing called standing relates to civil and criminal matters. Right? What's standing? Standing requires an injury. Somebody has to have their rights controverted because the purpose of the courts is to redress offenses where rights have been invaded. Okay. Now, again, I need to say this because I don't get a lot of people on here often. We're not promoting lawlessness. We're talking about the law. So we don't think we're above laws. We ask the government to obey the law, right? So I don't promote lawlessness. You do need to be driving correctly. You don't need to be speeding or running red lights or being intoxicated. None of that. You can't hang out with me if you do those things. No way. So We're not promoting lawlessness. All we're asking, this is what Martin Luther King said. He said, all we say is be true to what you said on paper. That's all we saying. And then they got rid of him the next day in Tennessee. They said, yeah, we don't do what we say on paper, buddy. They said the Supreme Court of Michigan said a plaintiff cannot rest his claims to the relief on legal rights and interest of third parties. That's what the police officer do every day. They say, oh, well, the state of Michigan is the injured party. But that's not possible, sweetie. What did it say for California? Please do Tennessee again. I was late. The word crime is connected to judgment. What did it say for California? So the evidence standards prior to pleading, or the problem is there is no evidence. If there is no injured party, there is no evidence. They don't admit no evidence. That's what's hilarious. They can't prove they have evidence of a crime. Evidence requires somebody outside of the government submitting something to the government, right? So I got it here. It says yada yada yada. No. Third chapter. Okay, here we go. Okay, they said this thing called a complaint. We just read what a plaintiff was, right? It's above my head. Okay, a plaintiff. Okay, this is every court case that's supposed to have a plaintiff. Every court case. Did y'all know that? Every court case. A court case cannot exist without a plaintiff. What's that Gucci Mane mixtape? Y'all don't know who Gucci Mane is. Gucci Mane got a mixtape called The State versus Roderick Davis or something like that. Okay, well, the state can't be an injured party. They'll lie and say, oh, well, actually, we prosecute things in the name of the state. Yeah, but it's supposed to be on behalf of an injured party. Okay, so there's no such thing as the state versus whoever. They do it because they get away with it, of course, but it's not supposed to be that way. Every court case is supposed to be Jeffrey versus Sherry. You know what I mean? Like something like that. It's supposed to be two injured parties. Even in district court, when two state governments want to go against each other, okay, well, it's Rhode Island versus Louisiana. Okay, it's supposed to be two. It's not supposed to be the government accusing somebody on who they're supposed to be protecting, right? So they said, I forgot where I was at, a plaintiff. Okay, well, a plaintiff makes a complaint. And they said a complaint is the allegation made to an officer, not made by an officer, which he don't make one. That's another hilarious thing. They don't make one. They give you a citation. They give you a piece of paper with a statute on it. Okay, well, that's not. Is there a way to correct them when they already have someone convicted? Good luck. It's called a void judgment, but good luck. And you have appeal times too. That's why it's important. You got to know your local court rules. Whatever, not it don't have to be local, but I'm gonna get you California, I promise. But wherever that action was created, you have to know that court's rules. Okay, like one time somebody was on here and I tried to help them. They had a case in Arkansas, but they lived in Georgia. And I was like, ugh. Okay, well, it's different when you can go to the court and you can ask questions or get documents or submit things. It's different when you live in another state, right? Because the case happens where the action happens. And that's in the Constitution. But it's called a void judgment, and you have so many days that you're allowed to appeal. So, but good luck, because that stuff's not always easy. Sometimes it's better to take the L. People don't want to hear it, but depend on the issue. I don't play with people's rights and people's life, so it just depends on the issue. But a complaint is an allegation made to an officer, not by an officer. Say to an officer. A complaint is made to an officer, not by an officer. California. A, B, C, D. California. They said in every prosecution for crime. How many? Every prosecution for a crime. Every every prosecution for a crime in California, every one of them, you have to establish evidence. They said evidence consists of two elements. They said facts establishing the injury, loss, or harm, and the criminal who caused the injury, loss, or harm. That is the Supreme Court of California. They said in every criminal trial, you have to do this. In California, I'm not, obviously this is everywhere, but you have to see it like there are no other states. Technically, your state is a nation. It's its own thing. The Supreme Court of California said, well, technically, this thing called the United States and California are two separate sovereignties. Okay, so when you don't deal with federal things when you're in the state. You're not supposed to be dealing with federal things when you're in the state. So uh they said again in another case, California court said, okay, in every criminal trial, how many criminal trials? Every one of them. The prosecution must prove the fact of injury, loss, or harm, and the existence of a criminal who created that injury, loss, or harm, right? Because sometimes you lose things on accident. Sometimes a loss occurs by accident. Sometimes damage occurs by accident, right? Uh, Sometimes harm causes is the result of an accident, right? So then they have to figure out, okay, well, was this a criminal action or was this a civil action, right? They both create a valid court case. So you need a injured party regardless if it's a civil action or a criminal action. But in order for you to label it a crime, it requires what they call criminal intent. And that 100% requires a victim of a crime. Okay? Louisiana. Louisiana said Louisiana has the code. Okay, well, they don't in a criminal action. I'm finna prove it to you. If you're on the Patreon, you should be on the Patreon. Louisiana said that all criminal actions are governed by the common law of England. Why? Because they can't go beyond the boundaries of the United States Constitution. Where's Louisiana? So Louisiana's got this thing called, well, they can't codify the common law. The common law is not codified. They act like they codified it, but they can't. That's not their first. The code is not the law, so it can't be codified. Um, just like Louisiana, I'm finna prove it in Louisiana, right? They said, oh well, in Louisiana we got the code. See, they say all crimes are commercial. I just told you for the past hour there was no such thing as a crime where there is no injured party. So no crimes are commercial. Zero crimes are commercial in America. In California, there are no commercial crimes. There's no such thing as a commercial crime. See, we believe it, but then we have to be confronted with the law. Okay, Supreme Court of Louisiana said this doctrine called stare decisis is a part of the common law tradition that has continuously governed criminal law in this jurisdiction from the time it was a territory of the United States. They said on May 4th, 1805, the territorial government of Orleans passed an act for the punishment of crimes and misdemeanors that contained the following provisions. They said all of the crimes, offenses, and misdemeanors herein therefore named shall be taken, intended, and construed according to and in conformity with the common law of England. They said the forms of indictment, the method of trial, the rules of evidence are to be according to the common law. They said, okay, in 1844, this thing called the Louisiana Supreme Court construed an act as incorporating the common law of England as they had it in 1805 into the criminal law of the territory, which persisted when Louisiana State was created. They said the common law is the source of law in criminal practice in Louisiana. They said cases abound in which this court has utilized the doctrine of stare decisis in criminal matters. Okay, well, that's a Louisiana Supreme Court case from 2025, I believe. 2020, my bad. 2020. Burglary fraud. Well, does burglary fraud require an injured party? Is it 25 for the physical book link? 25, yeah. It should be 25. It's $5 shipping, so it may be 30. ConstitutionAcademy.org. Let's see. I'm gonna add it to the cart. We're gonna find out. Add the physical and the digital. Physical, yeah, 25 for the physical. Yep, 23 plus $5 shipping. And it'll take typically about 2 weeks to get to you. He said, I just realized you're a sovereign citizen. What's a sovereign citizen? I don't know what that is. The law is the law. We agree. Nobody here has a problem with the law. Nobody here has a problem with the law. We've been talking about the law for the past 2 hours. What do you mean? And if the only people that can know the law are attorneys and magistrates, then we probably in real trouble. Because I'm not saying something that nobody should know. I don't have secret knowledge. These are things we're all supposed to know. And again, if the only people that can know these things are people who passed the bar exam, okay, then we're all in trouble, which we are all in trouble. Right? So, yes, it should be about 30. Let me see. Yeah, you put all the information in and it should be $5 more for shipping. Does that make sense? So Louisiana, did you get that? There's a difference between a civil action and a criminal action. Okay, in Louisiana, they can't go beyond the boundaries of the federal constitution. So they have the common law. Now, are you gonna get it? Good luck, right? It's easy for me to read this stuff and then you go face reality. But you're supposed to be reading these cases to them. They say, well, people tell me, I mean, not everybody tells me this, but 5 people have told me they've had their cases dismissed because they confront their fraud. They said, no, you got to have an injured party. The Supreme Court of Florida said, the Supreme Court of Louisiana said, the Supreme Court of California said, right? Remember, well, you may not remember, but every court outside of the Supreme Court is an inferior court. An inferior court only exists by statutes. You only connect to the statutes by way of by your consent. How do you consent? You went and got a state ID. You went and bought a car from a car dealership, right? So, this stuff is easier said than done, but we're supposed to be spreading this. I'm not giving you information for the courts for you to argue. This is stuff that everybody's supposed to know. See, this, if every American had this book, and this is not like nobody's buying this book for real, but I'm just being hypothetical. If everybody had the information that was in this book, well, you could end a lot of foolishness, right? Because that attorney's gonna lie until you can prove them wrong, right? See, they're gonna say, oh, well, the law is the law. Okay, well, let's talk about what the law is. What's the law in Iowa? What's the law in the 50 states? See, this is where we really get in trouble. This is where I really have fun, because they don't want to talk about what's the law. Let's talk about what's the law. What's the law? Somebody said Arizona and Florida. Okay, well, what's the law in Arizona? That's why they said Louisiana Supreme. I just read it to you. They said they do things according to the common. They have to do things according to the common law in Louisiana. The people in Louisiana don't know that. All they know is French law, French Napoleonic law, French Napoleonic law. Okay, well, that's only for civil actions. Civil actions require your consent in order for them to be affected against you. At common law, there was no such thing as a crime where there was no injured party. Technically, there was no such thing as a crime if there was no breach of the peace. That phrase is in the Articles of Confederation and in the United States Constitution. They said there's only a couple things that could put you in handcuffs in America. They said a breach of the peace and a felony. A felony is when you take something that does not belong to you or you damage somebody else's property. Of course, both of those things require an injured party. Okay, well, a breach of the peace requires violence, either about to happen or it's happening. Okay, well, the felony or the breach of the peace requires an injured party. So unless those things are happening, nobody's supposed to be put in handcuffs for no reason. For no reason. They say even in a misdemeanor, you couldn't do it. You know how crazy that is? They say you're not supposed to be putting people in handcuffs where there was no, even in the misdemeanor. Let's go to, I think Illinois says it best. Somebody's mad, like, I thought you were going to Arizona. Let's go to Illinois. Anybody here from Illinois? What states are we from? We're just yapping. I'm not telling you something that I've obtained this knowledge and you're not supposed to know it. No, we're all supposed to know it, right? That's how we end the foolishness, because they are gatekeeping this information, right? Missouri's in the house, Kentucky's in the house, North Carolina's in the house, Illinois is in the house. Watch this. They said, the Supreme Court of Illinois said, well, an act of the legislator is not necessarily the law of the land. They said a state cannot make anything due process of law by its own legislation. They said they just can't be writing stuff and calling it the law or calling it due process or calling it constitutional. These attorneys will look you dead in your face and say, no, because they passed it, then that means it's constitutional. What? Who told you this? They be teaching everything in these law schools, boy. They be teaching everything but the law. They said they go to law school and they spend 1 month out of 3 years on the common law of England. They said they spend 1 month out of 3 years. They say, yeah, they got this thing called the common law of England. They say, yeah, they got this thing called due process, the Magna Carta. Yeah, they supposed to get a trial by jury. But there's other stuff we got here. They said they spent 1 month on the common law of England. Okay, well, what's the law in Illinois? They said under the common law, constables and watchmen were authorized to arrest felons. They also had authority to make arrests without warrants in cases of misdemeanors, which involved a breach of the peace committed in the presence of an officer. They said no face, no case. What you mean? They said if it wasn't committed in his presence. Why? Well, you got to understand the times then. They didn't live in a reality where you didn't just get away with stuff back in the day. Okay, everybody kept that thing on them. Okay, they used to call it the Wild Wild West. They said you weren't getting away. We didn't have time to go get the sheriff. Yeah, they say, yeah, the sheriff will get here eventually, but we're going to handle this right now. No, you took something from me that did not belong to you. And we're going to take 10 steps back and pat out. Right? They said this thing called policemen were unknown to the common law. This is the Supreme Court of Illinois, y'all. They said a constable or policeman has no authority to make an arrest without a warrant. How much authority? None. Zero authority. They said arrests shall not be made without a warrant except for cases of felonies and breaches of the peace committed in the presence of an officer. They said if he didn't see it, what's that Dexter meme? Sorry, kids. But this is also when a morality level was when everybody knew the 10 Commandments and they taught it in schools, which is another maritime term. But okay, well, what's the law in Illinois? Let me see. Okay, the Supreme Court of Illinois said not until 40 years after the adoption of the Constitution that we proclaimed that the jury shall be the judges of the law in Illinois. They said this thing called Illinois adopted the common law of England as it existed prior to the fourth year of James the First. They said the common law of England and all such statutes and acts of British Parliament prior to the fourth year of James the First, not local to that kingdom, shall be the rule of decision and shall be considered as in full force. They said Illinois adopted this thing called the common law of England. They said when Illinois became a state, they adopted the common law of England as the rule of decision for Illinois courts. What? So when they say, okay, well, the law, what's the law in Illinois? The Illinois Constitution is not the law. We're just using Illinois as an example, right? What does a constitution do? All a constitution does is just create the government, right? Remember, people tell me all the time, well, the United States is a corporation. Okay, bet. Okay, well, the state of Illinois is a corporation. Okay, well, the Constitution created that corporation. And they created this thing called the legislature. They created this thing called the executive branch. And they created this thing called the judicial branch. That's all the Illinois Constitution does. Okay, when they created the judicial branch, they gave the judicial branch a stack of books and said, okay, well, that's the law which you measure all of these statutes and executive actions and court actions through. Okay, well, what was that law? Because everybody has a body of law. Okay, the common law of England is the body of law, right? We were talking about Louisiana, right? Well, why do I have to reinforce that Louisiana's criminal law is the common law of England? Because Louisiana adopted the Roman civil law as their body of law in Louisiana. The Louisiana Constitution just creates a government, but they handed the judicial branch a stack of books and said, this is the law which you measure civil actions through in Louisiana. They gave them a bunch of French books, and they said these are the French translations of the Roman law. Why? Because France has always been subjected to the Roman law, right? So when Louisiana joined the Union, okay, they said, okay, well, we still want that. Okay, well, we got this thing called the United States Constitution. You can't go beyond the boundaries of the United States Constitution. Okay, so when you call something a crime, you can't call something a crime according to the Roman law. See, the Roman law, you don't need an injured party to be called a crime. If we wrote it, oh, well, that's a crime. Okay, well, then you know what's happening all over the country now, right? But when you call things a crime in Louisiana, you have to call it like the original 13 states called it a crime, according to the course of common law. And you can't call things a crime where there's no injured party. They do it. I'm just saying they're not supposed to do it, right? So you get this thing called Illinois, and they gave the Illinois judges, the Illinois magistrates, a stack of books. And they said, okay, this is the law on which you will measure every action of the legislator, of the executive branch, and your judicial branch. And it's called the common law. They say it. They say, okay, the common law are all statutes, the common law of England and all statutes and acts of British Parliament down to the fourth year of James the First. They gave them a stack of books and said, okay, there you go, get to work. And then you get to this thing, okay, well, we talking about unlawful arrest in Illinois. Okay, well, they gave them that stack of books, and in that books, they say, okay, well, policemen were unknown to the common law. They said under the common law, constables and watchmen were authorized to arrest felons. They also had authority to make arrests without warrants in cases of misdemeanors, which involved breaches of the peace. Not all misdemeanors. And misdemeanors which involve breaches of the peace committed in the presence of officers. I'm reading this from my Patreon. It's called, what's it called? It's called Constitution Academy. The same name I got for this TikTok is on Patreon, and I'm reading from the Illinois collection. So I don't have all 50 states, but I'm doing my best. I'm just one guy. But every case that I find related to a particular state, I put that on there. So when I was searching when I was searching, I guess I was on unlawful arrest in Illinois. They got all this stuff about the common law. Okay, well, I attached that. So if somebody from Illinois needs to argue or make a defense or just spread this information to the other people of Illinois, bet you got these cases. Do I have Tennessee? I also have Tennessee on there. Right? So what's the law of Illinois? They said this thing called, when we make decisions in Illinois, it is based on the common law of England. All right. Now, don't be mad at me, y'all. I can't read all these. I'm not going to get to every state on here. Join the Patreon. Most of these states are on there. If it's not on there, that will help me research for you. I pay for most of this stuff out of my own pocket. Let's see. How do I connect with your Patreon? Patreon.com. It's a website or an app. You just search Constitution Academy. It's $5 a month. I say good luck. If you can download and screenshot and copy and paste everything onto a Google document in a month, I think you got your money's worth. I think you can do the year too. I think it's $60 for a year. And I got insane amount of law books. Insane. I got 27 law dictionaries on there. 27 law dictionaries. This book right here, this is just me compiling all the information. I'm not telling you anything. I'm telling you what they said. Well, I'm not telling you anything. This is what they said, right? When we say Tennessee, well, Tennessee said this. I don't have an opinion. I'm not, you know what I mean? I'm nobody. This is just stuff we're all supposed to know, right? Let me see. Some states will explain things better than others that I can find. California is where I found most of this stuff. And then I try to find that stuff in other states. Let's see. The common law of England, Let's go to Michigan. I like Michigan. Did somebody say Michigan? Missouri. Oh, I like Missouri. Watch this. Missouri's got it nasty too. They explain things really well. See, that's what they don't tell you. All these state Supreme Court cases is where they tell you all the stuff. People keep talking about the feds. No, we're supposed to be talking about our states. So what's the law of Missouri? The answer's the same. All right. Yeah, for everybody purchase the book, give it 2 weeks. It takes a week to print and then a week to get to you. All right. So you can, as long as my page isn't down. The website that you ordered from will have an email address if you really got a question about the orders. Missouri. The Supreme Court of Missouri said this thing called the Common Law of England was adopted in Missouri on January 19th, 1816. And they said the common law of England, made prior to the 4th year of James I, shall be the rule of decision in this territory, right? Okay, they said now when Missouri came into the Union, so they said they did that when Missouri was a territory, all right? Now when Missouri came into the Union, it brought with it the common law, which it had adopted in 1816. And they said the statute which we adopted, the common law of England, specifically includes the common law in force prior to the 4th year of the reign of James I, which was the year 1607. What happened in 1607? Y'all remember the Pocahontas song? What happened in 1607? They sailed the open seas for glory, God, and gold in the Virginia Company. Y'all remember that? Okay, well, that's when Virginia came on the scene. They said when they sailed the ocean seas for glory, God, and gold, they said they brought with them this thing called the Common Law of England. So when Missouri comes on the scene and they joined this thing called the Union, okay, well, they said, okay, well, we got the common law. They don't go further than 1607. They said they go 1607 on back. Right? Yesterday, if y'all were on here, we talked about Massachusetts. Massachusetts, they still citing cases in the Massachusetts Supreme Court from the year 1300s, from the 1300s under Edward III. where they're protecting people's rights based on old statutes that they found. I told you they were the Missouri judiciary was given a stack of books and said, there you go. There you go. When the legislator writes something, they got this thing called due process. Okay, well, this due process thing comes from the Magna Carta. Okay, well, the Magna Carta says and you can't take people's life, liberty, or property without this thing called due process or the law of land. They were given a stack of books. They tell you. Made prior to the 4th year of James I. Every king. Okay, so this is the common law of England. As early as they got books on it. The year 510 BC, this guy named Dunwallo Momushus cited the first 5 books of the Bible and called it the Mamertine laws for ancient Britain. This is before the birth of Christ. All right. And they said in these Mamertine laws, they cite the first 5 books of the Bible. In these Mamertine laws, they said these people had the right to travel unless you got paid. And then you have the right to bear arms. They had it in ancient Britain language, but this is all the same stuff that we're arguing about today. Okay, well, you get on the other side of the resurrection of Christ, you got these people called the Druids and the Danes and the Jutes and all these families that migrated to England either by conquest or just as immigrants. And you get to about the 300s, you got these people called the Angles and the Saxons. Okay, well, they invaded England and they married the ancient principles of what they called, I forgot to say this, Dunwallo Momushus' son, his name was Belinus. He called the Mamertine laws of his father the common law in whatever ancient language they had. All right. They recorded all this stuff. They recorded all this stuff before the Magna Carta. All right. Then you get to the resurrection of Christ. Then you got 100 and 200 AD where these people called the Druids. Okay. Well, they got a stack of books for these people on the Druids. They do. They have real stacks of books. They got more information than all of us could ever have. All right, then you get to the 300s, these people called the Angles and the Saxons. Okay, well, all the kings and their acts in their day and all the court cases in their day, they compiled all that information as best as they could. They say some stuff they don't just have an answer for. They don't have everything, but they were given a stack of books. The judges, the magistrates, they're not judges. The magistrates were given a stack of books, and that's what they're supposed to be enforcing. So when the legislator writes a statute, they have to say, okay, well, does this violate due process? Because due process says you can't presuppose a punishment before the jury has given an answer of guilty or not guilty. This is real stuff. They say the Constitution, the Bill of Rights, all the Bill of Rights come before the year 1066, all of them. So they said this thing called a trial by jury, which every state constitution has. Okay, well, that came from the year 1050, where they said that, we're going to set up a body of people to be the judges of the county, to be the judges of the law and the facts. And they say they got this from these people called the 12 patriarchs or the 12 apostles. These people called the Angles and the Saxons said they traced their ancestry back to the people of Moses. And these attorneys will look us dead in our face and say that we're not founded on a Christian country. Well, they lied. They lie every day. That's their job. Their job is to lie. There's not one attorney found in nobody's constitution. Right? So they said, okay, well, Missouri came into the Union and they brought with it this thing called the common law. They said the statute by which we adopted the common law of England includes the common law in force prior to the 4th year of James I, which was the year 1607. Okay, well, they were given a stack of books on each major king and their acts from the year 1607 as early back as they could go. They were given those books. Those books exist. Like that Massachusetts case, they said King Edward III. Go look up King Edward III. He's going to have a stack of acts and court cases from that time period. You may not be able to read it, but they've translated it for the magistrates. They know it. They were given those books. How else would they know it? They know it. They got it. They don't tell us, but they got them books. They said now when Missouri became a state, it created new governmental structure, including its judicial system. They said these new courts of Missouri, they said we want to separate. We want to specify that when Missouri was a territory, it was bound by the United States Congress because it was a federal territory. Well, when Missouri joined the Union, it got treated, and it's supposed to be treated like the original 13 states who were never federal territory. So they said it created new governmental structure, including its judicial system. They said this thing now called the Missouri courts didn't have no body of decisional law of their own. So they said they provided the state with a body of decisional law called the English common law as it existed in 1607. They say, okay, now we want to bring a correction. This section of the statute does not say that the English common law was enacted as a statute. They said the Missouri legislature can't enact things like that as a statute. It existed prior to the creation of this thing called the Missouri legislature, the Missouri state legislature. They said this section does not say that the English common law was enacted as a statute to be treated as a part of the statutory law of the state. They said no. The state, it states that such common law shall be the rule of action and decision in Missouri. They said you're supposed to measure all of these statutes against these stack of books called the Common Law of England. They say you're supposed to measure every executive action against these stack of books called the Missouri, the Common Law of England, down to the 4th year of James the First, which was the year 1607. And they say you're going to find the ancient principles of the people in these acts and statutes. And you're going to measure the actions of the legislator, of the judicial, of the executive branch against this stack of books. Good luck. But remember, you're not the judges in Missouri. Who are the judges of Missouri? The judges of Missouri are the people, called the jury. They are the sovereignty of Missouri. They said it says that the English common law of a general nature as of 1607 was made to be the decisional law of Missouri. They say when you make decisions on the legislature, on the executive and the judicial branch, you do it according to this thing called the Common Law of England. And then they said it in 2010, the Supreme Court of Missouri said Missouri's common law, because in 1,000 years and 500 years, okay, well, they're going to find this thing called Missouri. It may not be a Missouri in 500 years, right? So they say, okay, well, somebody's going to find this stack of books called the Missouri Common Law. And they're going to say, well, they talking about the year 1607 in here. What are they talking about? Okay, well, where did Missouri get it from? They got it from this thing called the Common Law of England. Right? Why is that significant? That's why they fought the Revolutionary War. You understand? That's why they fought it. Because the government was not obeying the law. What was the law in England? The Common Law of England. Yeah, they said the government wasn't obeying it. That's the thing we wanted. We don't have a problem. These attorneys on here, they say, oh, you super sovereign citizen, think you don't have to obey law. We didn't talk about the law all night. What are you talking about? We want you to obey the law. We don't have a problem with law. There's the king in England. His name was King Alfred. He compiled all the laws of his day. And he said, oh, well, yeah, all these laws come from this thing called the Decalogue. What's the Decalogue? The Ten Commandments. They call it the Doom Book. D-O-M-E, the Doom Book. They say, yeah, this compilation of laws that King Alfred compiled called the Doom Book is all based on this thing called the Decalogue. Okay, the Decalogue is the book of Deuteronomy explained. The book of Deuteronomy is an explanation of the Ten Commandments. And they said that's the Common Law of England. Y'all not ready. We ain't there yet. What else? Let me see. Let me find some other states. Michigan. I like Michigan. I like Michigan. Let's go to Michigan. See, they don't talk about that common law of England, do they? No, they want you to talk about the Constitution. Okay, well, you can't interpret the Constitution without this thing called the common law of England. I got cases on that too. Right? They say when you look at our Constitution, you don't know any of those phrases in the Constitution without going to the common law of England. Right? They got this thing in the Constitution. I done talked about it. It's called the breach of the peace. Okay, well, they got a whole body of law on this thing called the breach of the peace. Every phrase in the Constitution, every major phrase in the Constitution has like volumes of books on it. They were founded on the Virginia Company. Yes and no. They say there was a distinction between the Virginia Colony and the Virginia Company, right? So the Virginia Company was a corporate charter by, let's just say, King James, I guess. Okay, and then they sent a group of people to try to colonize it, and then over time people showed up. So yes, there were two groups of Virginians. There was the Virginia Company, which would establish a government and a colonization, and then you had the Virginia Colony, which is the people. So immigrants were also fleeing persecution. They were able to come here, and they brought with them the common law of England. That's really how we got those Amish people. Those people were fleeing Germany. They were fleeing ancient England, and they brought with them the common law. I got books on that too, where they say 1607, but technically they couldn't survive in 1607. They had to leave. They had to leave and come back in like 1613, because they couldn't survive. They not from here. That's not. I'm not trying to start no debate, but I'm just saying that's just what happened. They couldn't survive. They got major diseases. They had to leave and come back. They didn't come back until like 1613, and then they didn't really get the common law till like the 1630s. They had to fight to get the common law then, and then in 1660s they got they had a civil war in 1660s or something like that. So let me go here. Michigan common law. So what's the law of Michigan, y'all? What's the law of Missouri? All right. They said this thing called the common law shall remain in force, and that the common law has been adopted into our jurisprudence. And I want to make this distinction. I'm not reading some ancient cases from the 1800s. This case was from 2000. You have to add a historical timeline section to a book. I do. I'm trying, if I can ever get the money, I could have that common law book done in like 6 months. I know I know how to structure it. I know how to get the information. It just takes time. But the timeline, I can definitely do the timeline. I definitely plan on doing the timeline of the common law of England for sure. I made 2 videos about it on YouTube. So you'll see, let me see, Common Law of England Part 1, where we go over the timeline. And then Common Law of England Part 2, let me see what it's called. Yeah, I got a video called What is the Common Law of England? That's 13 minutes. I got the timeline of the Common Law of England Part 1 and the timeline of the Common Law of England Part 2. So the Part 1 is the real common law. The Part 2 is after the invasion of William the Conqueror all the way until 1776. So I have both of those. I have the major timelines on a video on YouTube. Michigan. All right, so they say, yeah, this thing called the common law has been adopted into our jurisprudence. All right, that was in 2000. They said in another case, okay, well, this thing called the common law prevails in Michigan. They said this state's common law is adopted from England. To identify such law, the courts will consider English cases and authorities. All right, they said this thing called the common law was adopted as the law. Not a law, not kind of a law, not part of the law. They say in Michigan, this thing called the common law is the law of this state. Let me read it right. They said the common law was adopted as the law of this state upon statehood and has since remained the law of this state. Again, that they didn't say that in 1846. They said that in 2014. They can't get rid of it. They want to. They ignore it. Oh, 100% they ignore it. But they can't get rid of it, especially not since the Civil War. All right, so they say again, this thing called Michigan became a state in 1837. They said since Michigan became a state in 1837, Michigan's jurisprudence has always recognized the pre-existing common law concept of sovereign immunity, which immunizes the sovereign state from all suits to which the state has not consented. Okay, well, who's the state in Michigan? You are. Got to get out of these commercial contracts. The Supreme Court of Michigan said the truth is the Bill of Rights and the American constitutions have not been drafted for the introduction of new law, but to secure old principles. They said there's no such thing as a new law in Michigan. Don't they say it on the news? They're going to say it tomorrow. They're going to say, oh, well, they passed a new law starting February 9th. If you don't do X, Y, and Z, punishment will magically be prescribed to you. Magically, no due process, no jury, no guilty or innocence. Your guilt's already been determined, sweetie. Don't worry about it. Starting February 9th, if you haven't done X, Y, and Z, no due process, no common law, no constitution. Nah, we don't do that. If you don't do X, Y, and Z, you're already guilty. Right? They said this thing called the Bill of Rights is not the introduction of new law. They said these are to secure old principles. Where'd those principles come from? They said they assumed that the existing principles of the common law are ample for the protection of individual rights. Let me see. I got another case. They said Michigan. Let me see. They say this thing called they talk about William Blackstone. So this is some good information. If you want to start learning this thing called the common law, let me see here. I think Michigan said it. Alabama's got some nasty cases too. Here we go. Who is this? Oh, it's the United States Supreme Court. They said William Blackstone's commentaries are accepted as this is the United States Supreme Court. If I don't say that, they're going to say, oh, you're spreading misinformation. So I got to tell you where the case came from. They said Blackstone's commentaries are accepted as the most satisfactory exposition of the common law of England. It has been said that more copies of the work have been sold in this country than in England, and the framers of the Constitution were familiar with it. I got another case that says that too. They said, this is the Missouri, I forgot about this. The common law is the guardian of the morals of the people and their protection against offenses notoriously against public decency and good morals. Let me see, they got another one that says like, I can't find it. Let's see. Blackstone. No, it was Edward Cook. Edward Cook. I'm not going to find it in time. Oh, well. All right, let's see. What else? So Pennsylvania, Ohio and Pennsylvania. Tennessee. What's the law of Tennessee, y'all? Here we go. Tennessee's nasty now. Tennessee don't play. Tennessee, see, these states be teaching us different things about the common law of England. See, the Tennessee taught us about the significance of names. Watch this. Oh, Tennessee, I forgot. I be forgetting I got stuff on Tennessee. I got a bunch of stuff on Tennessee. Look at this. All right. And they confirm, all these states just confirm all this stuff. The Supreme Court of Tennessee said the history of the use of names in England is the source of our common law. They said, again, I just told y'all this, until about the time of the Norman conquest, there was no such thing as a surname. Okay, well, who is William the Conqueror? William the Conqueror, when he took over England, there was a regime change in England. Okay, so I say this again, the real common law you will find prior to the year 1066. That's the what they call the lex non scripta, the unwritten law, right? So when you get to William the Conqueror, just know that everything in England changed, and that's when they complained the most about government up until 1776. Okay. All right. So they said the history of the use of names in England is the source of our common law. Until about the time of the Norman conquest, there was no such thing as a surname. That's crazy. There's no such thing as a last name in. See, this commercial thing goes deep because what we know that last names used to be whatever the dad did in his day, right? Okay, well they said, well, prior to William the Conqueror, we didn't do that. You only had a first name and a middle name. Right? So they said there was no such thing as a surname or a family name. Each person was identified only by his Christian or given name. This is the Supreme Court of Tennessee, y'all. This is nasty. They said the custom of using surnames developed slowly with only sporadic use of such names until the practice became prevalent about the beginning of the 14th century, so the 1300s. They said about the fourth year of the reign of Edward the Fourth. There you go. See, they'll tell you. So somebody in Tennessee's got a stack of books on what Edward the Third and Edward the Fourth did. All right. They said by the fourth year of the reign of Edward the Fourth, 1465, statutes were adopted requiring the use of surnames. They said surnames were adopted and abandoned at will. They said the common law tended to place more stress on the baptismal than the surname. They said, Edward Cook said, special heed needs to be taken to the name of baptism, for that a man cannot have two names of baptism. Oh, it's so much I want to say. I can't. The Christian name, this ought to always be perfect. They said all laws, they said based on the Tennessee Constitution of 1796, all laws and ordinances now in force and use in this territory shall continue to be in force and use in this state. They said we adopted this thing called the common law. As it stood at 1776 before the separation of the colonies, our common law is derived from North Carolina, which Tennessee was carved out of. They said the Acts of North Carolina in 1715 and the Acts of North Carolina in 1778 preserved the common law that we have today. They said thus Tennessee through North Carolina adopted this thing called the common law of England. And we can only, oh, this is nasty. They said we can only turn to earlier English works and to decisions from other jurisdictions. They said a person usually bears the surname if he so pleases. They said a person is at liberty to choose and bear any name he likes. I have this book called The Biblical View of Commercial Law. Those who were on the website, I got a whole chapter on here on names. Y'all know what the Bible says about the devil, that he's the accuser of the brethren. Okay, well that's what he uses. He uses that false name. These scammers on the internet will tell you the all caps and all that stuff. It's all true. The devil gives you Kool-Aid with poison inside of it. So there's always some truth in it. Let me see if I can find it. I'm not gonna read. I can't read it because I'll come up missing tomorrow. But it's all in the name. That's why this common law of England thing is significant. That's why they don't talk about it, y'all. I'm not some conspiracy theorist. You're going to learn when y'all get these books. I prove everything. I tell you exactly where I get everything from. You join the Patreon, I'm going to tell you exactly where it came from. I didn't come up with this stuff. I didn't make up nothing. I cite all my sources. I am a human bibliography. Never mind, I'm not going to do it. But if you really want to know about the name, it's in that book. But yeah, that's Tennessee. So remember, the common law of England was before, the real common law of England was before this guy called William the Conqueror. When William the Conqueror came on the scene, he introduced the beginnings of what they call the Lex Mercatoria, or commercial law, where everything was on paper, and they started using surnames and commercial identification and all of this stuff. The Supreme Court of Tennessee will tell you, yeah, but before this thing called William the Conqueror, they didn't do none of that. And technically, it's not the law in Tennessee. Remember, we just read in Missouri, they said prior to the year of such and such date, they used this thing called the common law. Right? All right. Now, the Supreme Court of Tennessee said that that on all indictments, the jury shall have the right to determine the law and the facts. Who determines the law in Tennessee? They said this thing called the jury shall have the right to determine the law and the facts. They said by the immemorial traditions of the common law, the jury shall have the right to determine the law and the facts. The Supreme Court of Tennessee said that you, the jury, are the sole judges of the facts and of the law. Who are the judges of the law in Tennessee? Somebody said this is mixing church and state. How is this mixing church and state? You don't know what the mixing of church and state is. See, the law, the Bible says that Luke 24 on the road to Emmaus, Jesus said that all of the law and the prophets are concerning me. He said, y'all think this thing come from the Ten Commandments? Who do you think gave Moses the Ten Commandments? He said it was the Lord that called to Moses from the burning bush. He said, who do you think that spoke to Moses on the mountain? He said, who do you think was walking with Adam in the cool of the day? They said this guy named Enoch was walking with God until he was not. They said Abraham walked with God. God called to Abraham and he said, walk before me. And I will lead you to a land that I will show you. And they said that this guy named Abraham obeyed the commandments. There was no such thing as the Ten Commandments in his day. Jesus comes on the scene and he says, before Abraham was, I am. He said all of the law. How much of the law? All of the law is concerning me. He said, you don't think you know the law without going to the source. Who's the lawgiver? Law don't come from people. You think law came from a guy in a black robe? That's not the law. You get to the New Testament and this guy named Apostle Paul said, okay, well, the law is a tutor that will lead you to Christ. Why? Because the law, the prophets, and the teachings of apostles all lead back to this guy named Jesus. I keep wanting the crowd to shrink, but they don't shrink. Where did they get this thing called the jury or the judges of the law in Tennessee? They said this thing comes from the common law of England. They said these are the immemorial traditions of the common law. Okay, well, what are the immemorial traditions of the common law? That the people are the jury, or the people are the judges of the law and of the fact. From the year 1050, under this guy named Edward the Confessor, they established principles in his day that said that, oh yeah, we're going to encompass this thing from the 12 patriarchs or the 12 apostles. Because Jesus said that the 12 would be the judges of the nations. They said, bet. Okay, well, what's the nation? Who are the judges of the nation of Tennessee? Who are the judges of the nation of Florida and Arizona and Texas? Okay, they say you, the jury, are the sole judges of the facts and of the law. They said the jury, this is another case. The jury are the judges of the facts and of the law. The jury are the judges of the law. The Supreme Court of Tennessee said, oh, well, yeah, we're not the judges. We're just the magistrates. We just keep the books. We sweep the floors. We lock up the doors when everybody done. We clean the toilets. They said, we're not the judges here. You don't have no rights that don't. You don't have no rights to argue from if they don't come from Jesus. You can get mad about that all you want. But this is not about the church. We haven't talked about the church. We're talking about the law. The law comes from a lawgiver. Just like the planet came from a creator. A sandwich came from a sandwich maker, right? So they said this thing called the jury are the judges of the law. Why? This guy they said that he'll write the law in your heart. They say you bring every case before the people and they'll decide. That's why I can't give you legal advice. Because it's up to the jury to decide. And if we haven't been doing what Jesus did and feeding people and telling them the truth, okay, well, by the time it gets to the jury, it's up to them now. So you don't get to break the law. The jury will decide. Right? All right. Well, this thing called Tennessee, they said our state constitution prohibits imprisonment and deprivation of life or liberty, but by the law of the land. The origin of this phrase in the Tennessee Constitution is the Magna Carta. Where did this phrase from the Tennessee? They said this is based on Article 1, Section 8 in the Tennessee Constitution. They said this phrase prohibits imprisonment and deprivation of life and liberty, but by the law of the land. What's the law of the land in Tennessee? They said this thing comes from the Magna Carta, before there was ever such thing as a Tennessee. They said in another case, since the Magna Carta was sealed by the King of England in 1215, the trial by jury has been recognized by poets, statesmen, judgments, and others in eloquent and passionate terms. The institution of the trial by jury has been sanctified by the experience of ages. It has been recognized by the Constitution of every state in the Union. It is deemed the birthright of Americans, and it is deemed that liberty cannot subsist without it. Why did they fight the Revolutionary War? Because somebody was taking away from them what they called the accustomed and inestimable privilege of a trial by jury. They said that's the reason we strapped up. They said that's the reason we dropped bodies. Because you don't get to take us before this guy in a black robe and he gets to take away our life and our liberty and our property without the judgment or the law of the land or the judgment of our peers. Let me see. I got the Magna Carta. I forgot to say this. The Magna Carta is on the Michigan government's website. They said section 39 or Article 39 of the Magna Carta says that no free man shall be taken or imprisoned or disseized or outlawed or exiled or in any way harmed, nor will we go upon or send him save by the lawful judgment of his peers or by the law of the land. They got that exactly from the Magna Carta. They said this thing called the Tennessee Constitution cites it from the year 1215. They said that's where it came from. They said this institution of a trial by jury has been sanctified by the experience of the ages. And it is recognized by every constitution of every state. Ain't that nasty? What else? Somebody said Ohio and Pennsylvania. Pennsylvania, Ohio. See, has the Super Bowl ain't even started yet. Ohio, Pennsylvania. Pennsylvania Supreme Court said to accuse the legislator of an attempt to break their promise in the presence of Almighty God to support the Constitution, which declares that no citizen of Pennsylvania shall be deprived of his life, liberty, or property unless by the judgment of his peers. They said, what law? They said the design of the Pennsylvania Constitution Convention was to exclude arbitrary power from every branch of government, and that there would be no exclusion of it if such rescripts or decrees were allowed to take effect in the form of a statute. They said, okay, well, there would be no purpose in this thing called due process if the legislator could just write whatever and presuppose to take away your rights. They do it every day. They said if this thing could take a form in the form of a statute, call an attorney tomorrow and ask him what's a crime. They said, oh, a crime doesn't require an injured party. It's the violation of a criminal statute. Right. They said the right of property has no foundation or security but by the law. They said when the legislator shall successfully attempt to overturn it, the liberty of the citizen will be no more. Okay, well, that's what's going on. When they think that the legislator is God. You know what a statute is? A statute is the customs and bylaws of a corporation. Okay, well, that can't be the law. What's the law of Pennsylvania? Due process. Who are the judges of Pennsylvania? Here we go. Oh, where was I at? I was reading a book. Now I can't think of it. But they were talking about William Penn. And William Penn. Now I can't think of it. But it was something significant about William Penn. Oh, I know what it was. It was when William Penn, when people were migrating to whatever it was called before Pennsylvania, he said the people had liberty of conscience. But the Pennsylvania Supreme Court said that you will distinctly understand that you are the judges of both the law and fact in a criminal case. They say you are not bound by the opinion of the court. You know how crazy this stuff is? These people look you dead in your face and say, no, you have to take the instruction as the magistrate gives it. What? Who told you this? I'm telling you, these people, they say, oh, well, you got to do with the judge. It depends on how the judge is feeling. That's not the judge. The Pennsylvania Supreme Court said Pennsylvania has judges. You know, what's the word? It's chancellor. I got it on the Patreon. What is a chancellor? A chancellor is a judge in an equity court. Watch this. See, they don't tell you this. The chancellor is supposed to be sweeping floors. Watch this. Chancellor. What's a chancellor? That dude's supposed to be sweeping. He's supposed to be cleaning toilets. Yeah. In Latin, it's called the cancellarius. Okay. The cancellarius in ancient law is a janitor, or one who stood at the door of the court and was accustomed to carrying out the commands of the judges. Who are the judges in Pennsylvania? They said that dude's not the judge. See, an attorney will say, oh, well, it depends on the judge. We'll see what the judge has to say about that. We got to get a court order from the judge. What? That's not the judge. That dude's a janitor. Don't say that in there. He will put you in prison. He will hold you in contempt. Right? This stuff is nasty. They said this guy called the chancellor, the guy in the black robe, which I think I made a video about that on YouTube too, where they all come from Rome. In ancient law, this guy called the chancellor is a janitor. That dude's supposed to be cleaning toilets. He's supposed to get the plunger out, sweeping and mopping floors. They said a janitor, or one who stood at the door of the court and was accustomed to carrying out the commands of the judges. They said this office of chancellor is of Roman origin. From the Romans, the title and office passed to the church. Every bishop of the Catholic Church has to this day a chancellor. The jury is not bound by the opinion of the court. Not you by yourself. Yeah, we got to stop thinking that sovereignty means just me. It means your community. It means the jury is not. You need to tell the jury that they're not bound by the opinion of the court. Yeah, so that's who they call judge. That's not who the judge is. Who are the judges in Pennsylvania? They said the magistrate told the people, the jury of Pennsylvania, that you will distinctly understand that you are the judges of both the law and the fact in a criminal case, and that and are not bound by the opinion of the court. What's the opinion of the court? Sometimes that word judge and court is used interchangeably in a civil case, right? So that guy's supposed to be in charge of the ceremony. He's supposed to make sure that both parties are not yelling and about to fist fight each other, right? That's why he's got the gavel, order in the court, right? Okay, well, when they give the jury instructions, they're supposed to tell them that you are the judges of both the law and the fact. But what they've been doing is, probably for years, probably since before I've been born, they've been telling the jury, well, you have to believe the law as I explain it to you. Okay, well, you don't have you don't have the power to explain the law. If it ain't in the Pennsylvania Constitution, you don't have the power to do it, right? Who are the judges in Pennsylvania? They say you are both the judges of the law and the facts. They say you are not bound by the opinion of the court, and you may judge for yourselves. And if you feel it your duty to defer from us, you must find your verdict accordingly. They said that. They said this guy called the judge, the magistrate, cannot take the place of a jury, even by the consent of a defendant. They do it every day. They say, oh, well, you could get a trial by jury or a jury trial, or we might be able to make a deal with the judge. We just need you to sign right here. What they call it? A plea deal, a plea bargain. They say, oh, you don't want that jury. They're not educated in the law. Remember, there were no law schools when the Constitution was created. None. They had one law program at the College of William and Mary. And they gave them a stack of books and said, get to reading. There was no bar association. There was none of that here. They said this guy y'all call the judge cannot take the place of a jury. even by the consent of the defendant. They say you can waive a trial by jury. They'll look you dead in your face and say you can waive it. There's no law that says you can waive it. The United States Constitution gives the same command as the Ten Commandments. In the Ten Commandments, they say you shall not steal, you shall not kill, you shall not covet, you shall have no other gods before me. Okay, you get to this thing called the United States Constitution. They say the trial of all crimes shall be by jury. That's an instruction. That's a command. That's a commandment. They said, who told you you could waive it? Oh, it looked like somebody violating the Constitution of Pennsylvania and the United States. That's like double treason. Double treason. They say, oh, well, if you can waive it. You want to waive it, get an expert. He may be able to work out a deal with you. They do it every day. That New York said specifically. They say, and Florida says it too. The Florida Supreme Court said, yeah, this thing called a trial by jury is inviolate and it cannot be waived. They waive it every day. They waive it every day. They dang near don't give you a real trial by jury. People say it every day. Oh, what's the difference between a jury trial and a trial by jury? They said, Pennsylvania Supreme Court said, you will distinctly understand that you are the judges of both the law and the facts in a criminal case. You are not bound by an opinion of the court. You may judge for yourselves, and if you should feel it your duty to defer from us, who is us, the magistrates, you must find your verdict accordingly. They said the judge cannot take the place of the jury even by consent of the defendant. They get people to waive a trial by jury every day. You're not supposed to be able to waive it. There's no law that says you can waive it. They create a statute like it's the law and say, "Oh well, if you sign these magical papers, we'll give you a plea bargain from a judge." Okay, well that's not the judge of Pennsylvania. Let me see. There we go. They said, okay, here we go. This is fantastic. The Supreme Court of Pennsylvania said the legislator cannot confer sovereignty. They said the sovereignty in Pennsylvania is vested in the people and the people alone. These cases are so nasty, y'all. No wonder they call me a conspiracy theorist. This stuff sounds unbelievable. Because you go outside this court case and you go look at the real world and we don't see no sovereignty and no people out here. We see people being pulled over with no injured party. That's what we see. We see people getting tickets and being put in handcuffs without due process. That's what we see. Right? They said this word commonwealth is a symbol typifying or signifying sovereignty. They said in New York, they just say the people and that means sovereignty. They said in the early days of Pennsylvania, they used to say res publica or the republic. That's the Supreme Court. How do we seek reparations? You might not get it. It depends. It all depends on the case, the circumstances, and the times of appeal. You would have to know those court rules. You have to know your individual court rules, district court or county court, federal court or state court. They said the entire article of Article 1 of the Pennsylvania Constitution is the Declaration of Rights. The entire article, called the Declaration of Rights, is concerned with establishing the principle that the people are the sovereign in Pennsylvania. They said the purpose of the Declaration of Rights in the Pennsylvania Constitution is to guarantee and make absolute the principle that the people are supreme. They said all of which is called the Declaration of Rights for the protection of the people who are the sovereign. They said there is no sovereign in Pennsylvania except the people. They said a sovereign is not amenable in any court unless by his own consent. Now they said in one case that the sovereign was the people. They say in the next case that the sovereign is not amenable in any court. They say you're not even supposed to be in there unless you consent it. People tell me all the time, well, the judge is a banker, the judge is this, the judge is that. Okay, well, how you end up in there? Now I know corruption happens. I wouldn't be on here if they weren't corrupt, right? But they said we're not even supposed to be in these people courts. They said in another case, this thing called sovereign immunity is a creature of pure common law. They said the state's immunity from a suit was a firmly established doctrine of the English common law, a principle of a common law which has its roots in ancient common law of England. They said we're not even supposed to be in there. What other states? What I was gonna say? The jury, Indiana, Pennsylvania, Virginia. Let's go to Virginia. Texas and Virginia. Did I go to Texas already? I feel like I didn't go to Texas. Somebody's like, no, I've been here for 2 hours waiting on you to talk about Texas. Sorry, Texas. Let's see here. That is not Texas. Texas. The Texas Supreme Court said all causes, civil and criminal, shall be tried by juries. How many causes? How many causes? The Texas Supreme Court said all causes, civil and criminal, shall be tried by juries. How many causes shall be tried by juries? Who are the judges in Texas? Who are the Texas judges? Is the guy in the black robe a judge? Mm-mm. This stuff is nasty, y'all. They said we adopted this thing called the common law of England, and we repealed Mexican laws as a result. They said this thing called the common law of England shall be the rule in this republic and shall continue in full force until altered or repealed by Congress, which they've never done. And I know this because I got cases from 2025 that say the common law of England is the law of Texas. They can't do it. It's a case. If you're on the Patreon, go to Texas. I'm reading. Okay, let's not say forced, because you wouldn't be in there if you didn't have a state ID. We got to stop saying, oh well, forced. They made us. They didn't make you do nothing. Nope, nobody told. Y'all can't say that to the Amish that they forced them to do anything. Those Amish people do what they want to do every single day. I'll never forget one day we were leaving an oil field job in Ohio or Pennsylvania, and we passed by this house. If you need to work, you have to sign. Work for who? Work for a corporate entity who's governed by commercial law? Nobody told you to go apply to that job. Go admit we don't have real skills. The Amish people didn't fill out no job applications last week. They have skills. Yes, corporations. Okay, well, if you participate with corporations, that is not constitutional. You choose to waive your rights when you participate in commerce. So you don't get to argue the Constitution when you told yourself that you just signed paperwork that you did not have to sign. You could have went without a job. The Amish do it every day. You can't pull that stuff. No, not under duress. No, can't say that. We cannot work. You can't say that to the Amish people. Who can't work? Work for who? Work for what? Who told you you can't work? You can't tell those Amish people they told them they couldn't work. They work every day. They're working right now. Well, they're not working right now. One time I was in Ohio, Pennsylvania. We drove past this house. It was like 30 Amish dudes. They just sitting on tree stumps, eating their little hay, doing what they want. Are you insinuating that everyone should become farmers and live off the land? I'm not insinuating anything. I'm saying Americans can do whatever they want to do. That's how the country started. That's what was happening when y'all complain about this thing called the United States Constitution. They were all farmers. They were all living off the land. That's just not true, though. Again, in 2026, they got these people called Amish people in New York, West Virginia, Ohio, and Pennsylvania. Some say they in Mississippi. Some say they in Tennessee. And they don't work for no man. They work for themselves. They don't fill out no paperwork. What do you mean the world could not run? The Amish people don't care what's going on in the world. The Amish mind their business. And they don't fill out no fake paperwork. They don't have no birth certificates. They don't have no social security cards. They don't have no bank accounts. She worked for Amazon as the delivery. Stop. You don't get me banned. They're going to report the page and then I'm going to be gone tomorrow. The world could not work. I thought we were talking about states. We don't care about the world. We were talking about Texas. Texas is a sovereign and independent state. It's in Article 1, Section 1 of the Texas Constitution. Do you want a doctor? No, I don't want a doctor. No, I don't want medicine. No, I don't want technical help. Do you like your cell phone? No, I do not. I hate all this stuff. It's all trash. It's all garbage. It all requires this thing called fake electricity. And I would be better off without it. We'd all be better off without it. Right. I'm saying we're supposed to be off these platforms. It's all garbage. I'm censored. It's so crazy. Again, this ain't got nothing to do with my rights, though. Because how do the courts know who you are? That they could presuppose to take away your constitutional rights. So you keep complaining about the courts, but how do the courts know who you are? Because a sovereign can't be brought into the courts of its own making without its consent. That's the law. See, why do the Amish the only time the Amish get in trouble is because they're not on their computer. And they keep having kids that are not on their computers. And they keep not sending them to schools that are not on their computers. See, she don't know what a doctor is. See, when this country started, there was no such thing as a doctor. And I don't have time, but I'll give you a theological lesson. In the Bible, there was no such thing as a doctor. I just learned this. See, this is why this common law of England thing is significant. The last Saxon king of England, his name was Edward the Confessor. Go look this up. Edward the Confessor. He was the last Anglo-Saxon king before William the Conqueror. That dude lived so godly that when he died, they built a shrine, like a little fake temple for him, and people would go to that shrine and they would get healed of infirmities. I'm talking about the BBC network it makes documentaries on this dude. Okay, I learned this word yesterday. Asclepian temples. I'm going to copy and paste it and put it in the comment section. Okay, everything you think about a doctor it comes from these people right here. An Asclepian temples. Go look that up. That's all demonic witchcraft. They got this thing called pharmakia. That's where all medicines are created. It's where they mix potions and they mix unnatural things. And the thing that they presuppose to heal always comes with side effects. That's why the Bible says that herbs would be the healing for the nations. There was no such thing as a doctor. There was no such thing as a doctor at the founding of this country. All hospitals are foreign. Did you know that? I have this on the Patreon. All hospitals are foreign. All of them. None of them are American. There's no such thing as an American hospital. There's no such thing as an American medical system. The Supreme Court of Alabama said that healthcare is not found in the general welfare provision of the United States Constitution. Qualified by who? There's nobody lawfully authorized to qualify anybody in this country. See, I told y'all these people called the Angles and the Saxons trace their ancestry back to the people of Moses. No, we're not on the same page if you talking about the government kept doing all this to you, but you willfully consented. No, we're not on the same page. At all. Look at this. What's a hospital? A hospital is a religious house. Okay, when the Constitution talks about this thing about separation of church and state, that's what they were talking about. That's why the Supreme Court of Ohio said that birth certificates were unconstitutional. That's why the United States Supreme Court said records of birth are not admissible in court as evidence. That's why when I talked to those Amish people, they said they didn't have no such thing as a birth certificate. So everything you complain that the government's doing against you, you consented to that. Because the government should not even know who you are. See, I just say the Amish. I don't know no Amish person's name. Jedediah. I'm sure that's a common name, but that we just be making fun of them. They said this thing called a hospital is a religious house. And they use that thing called the hospital for the use and exercise of religion. That is not the common law of England. That is not constitutional. Well, no. Don't say it hasn't done anything to me except allow corporation. No, you can't. The government can't allow anything. If I don't go to McDonald's, McDonald's don't make no money. I went to Zaxby's today. Okay, well, if I don't go to Zaxby's, Zaxby's don't make no money. Don't say, oh, well, the government did this. Well, Zaxby's is a corporation, sweetie. If I don't show up and ask for a chicken sandwich, they don't give them out. Consent requires you to do something. You know, one time I was in Maryland. I was in this place called, I think it's called Oxon Hills. Okay, well, they got this place called a barbecue place in Maryland. Okay, well, no disrespect to Maryland, but that you're not supposed to be going there for barbecue. Okay, there should be no barbecue places in Maryland. I went to a barbecue place in Tennessee. I almost burnt that building down because that is not barbecue, and they should not exist because people should not be going there. Right? I went there because I consented. Okay, well, if you can't work and feed your family without corporate fictions, then that's something you got to deal with. But you can't say Walmart did this to you because nobody told you to go to Walmart. Just admit you don't have the skills to take care of yourself. That's okay. I'm not your judge. But just admit, hey, I'm not in a position to make it without commercialism. Most of the country is not. I'm not your judge. I'm not shaming anybody. But that is the reality. We complain that really what we're not admitting is that we don't have the skills to take care of ourselves. My mind is closed on being objective. You're the one complaining that the government did this to you when you're not admitting. Who's the closed-minded one who's admitting they don't have the skills? See, those Amish people don't have no excuses. They don't even have electricity. They make their own clothes. They grow their own food. They work for themselves. And they don't complain about how the government is mistreating them. They get on their horse and buggy and mind their own business. No, because people need to know this. This is good. This is how I wrestle with attorneys. See, this is not about y'all. This is about getting my argument skills up. I'm 63. I have lots of skills. I could log on. Okay, well, I am assuming you're complaining that the government did this to you. Don't say now that you have a lot of skills and then complain that corporations are doing this to you. Nobody told you to go participate with corporations. Not one law. You won't find one law that said, oh, go here. See, these Amish people don't have no excuses and they don't complain. You don't even know they exist. If I'd never worked up in there in the oil field, I'd have never seen them. But nobody told you to participate with corporations. Corporations have always existed. Corporations existed in the time of Jesus. See, people don't believe they choose to do things. Even in ignorance, you did it. Don't say it. People say all the time, oh, brother, well, they tricked us. Oh, I read books for a living. I don't have no job. See, I do what the Constitution say. Gold and silver. They said, the Supreme Court of South Carolina said at common law, only gold and silver were considered money. Okay, bet. So what I got? I got gold and silver. It's outpaced every Federal Reserve note. What my actual job is, reading. That's my actual job right now. Oh, this is so fun. They said, ask them this, ask them this. They be using the bots and attorneys. They be saying, oh, well, now ask them this. They say, well, how do you pay taxes? And I say, well, what statute? What taxes? You won't get an excuse out of me. And you won't ever see me showing pity. Because people don't act like they consent. That's the number one thing. People act like they've never been to the DMV. People say, oh, well, the government did that. Well, how do they know who you are? Well, they told us. You didn't read the Constitution. And again, I say this all the time. Well, you don't complain about how the government's mistreated you until after you've gotten in trouble. And now it's all they taking away our rights, arbitrage and all that. Well, nobody told you to go there. Let's admit it. I don't have no skills. I can't build a log cabin tomorrow. Now I got some gold and silver to make somebody build a log cabin, but let's just be for real. Nobody wants to be honest anymore. We want to act like we just want somebody to blame to make up for the fact that we don't have no skills. I don't have no skill. I know how to hunt. I could go eat. I know how to build a log fire. Or not a log fire. I know how to build a fire. Right. But that's not the corporate world's fault. Why didn't your mother and your father teach you life skills? Why didn't your grandparents teach your parents life skills? Somebody dropped the ball along the way, and it wasn't the government. We blame everybody but ourselves. We say, oh, well, the government did this. The government tricked us. Every contract requires full disclosure. What? You asked for this. What are you talking about contract? We're not here about contract. That's what happens when people be in court. They be held in contempt. Talking about the common law. The common law. They said we're not here about the common law. No constitutional rights. You wasn't talking about no common law when you're in line at the DMV or when you're at the car dealership or when you sign those papers. We're not here about your rights. Oh, yuck. The common law. In contempt. $500. Yeah, again, you can't say that to the Amish people who live in today's world. So you can point at me, but I'm going to point at the Amish people and say, well, it's 2026. They make their own codes. They make their own clothes. They grow their own food. They go wherever they want. They go into Canada today without passports. I said that yesterday. They go into Canada without passports. So you can't say, oh, well, nobody's doing this. No, somebody's doing it. Don't say nobody or we all. I don't speak French compatible with today's world. I can take you right now. You can get on the Greyhound and get dropped off in Lancaster County, Pennsylvania. And you can't use that argument against those people. You can't say, oh, well, the government tricked. They didn't trick them. They kept their history. They knew exactly what was going on after the Civil War when they set up these county offices and talking about you got to go register your land now. They said, no, we just fled that in ancient Germany and ancient England. We're not registering nothing. And they don't pay no property taxes. They don't pay no income taxes. They don't have income. They also don't bank. So you can't, they don't bank in 2026. So you can't say, oh, well, that's not compatible with today's world. They don't have no banks. Not the devout ones. They got the little cool ones now. I seen one in the Audi one time. I said, he said they got air conditioner now. He said, yeah, they got banks and air conditioner. I'm finna sign up. So you can't use that argument, oh, well, they're just doing this to us. They're not doing it to all of us. Don't say we. I don't speak French. I'm not from Louisiana. Just say you don't obey the law. Just say you don't know the law, you consented, and now you want to complain about rights when they're encroached upon you for participating in commercial actions. It's okay. I'm not your enemy here. You complaining to the wrong people. You need to explain that to a jury. You make a great argument. Okay, well, bring it to the lawful judges of your state. See, everything we complain about, the Bill of Rights gives us an answer for. They say the government's being corrupt. The government's doing this. The government. Okay, well, this Declaration of Independence gives us some great ideas. What is it? Let's go to Texas. We're here in Texas. Texas says, oh, yeah, where's it at? Texas, the big dogs. Texas, watch this. They said this thing called the territory properly included within and rightfully belonging to the Republic of Texas created a Republican form of government to be adopted by the people of the Republic. And they said they are admitted as one of the states of the Union. They said again, this Constitution thereof with the proper evidence of its adoption by the people of said Republic of Texas. They said, again, the present Republic of Texas is admitted into the Union by virtue of this act on equal footing with the existing states. Okay, now you get to the Supreme Courts of Texas. They say, okay, the Texas Constitution in Article 1, Section 1. I got the Texas Constitution in one of my closets here. In the first page of the book, they say, okay, yeah, Texas is a free and independent state. The heading above that says the freedom and sovereignty of the state. All right. So the Texas court said in 2016 that this thing called Texas has retained its sovereignty and its immunity to allow private suits against it in its own courts. They said, well, you don't end up in court unless you consent, unless there's an injured party, or unless you consent. They said this thing called the Texas government doesn't have sovereign power. They said the citizens of the Texas should not be deprived of property, privileges, or immunities. But they said the people of Texas do have the sovereign power. And then they said this thing called, this is the Supreme Court of Texas in 2007. They said the people of Texas are sovereign and possess all the powers of sovereignty. They said the faith of the people of Texas stands pledged to the preservation of a Republican form of government. That's not what I'm looking for. It's good. They said, okay, well, based on Article 1, Section 2 of the Texas Constitution, says that the people have sovereign rights and privileges that are beyond the power of the government. It doesn't take money to grow food. Nope, it doesn't. So most people don't have money no way. What is money? Again, you got to go to the common law of England to know what money is. But that's not what, let's see. The Texas Constitution says they have the right to alter or to abolish their government. I want to read it right because they'll flag the page if I don't read it right. The Supreme Court of Texas said it is that the American people are the sovereigns and in them is lodged all power. And the agencies of government possess no authority. How much authority? None. Y'all think I'll be making this stuff up. Let me see. Texas Constitution. I would go get the book, but I'm not going to. Texas Constitution. See, we didn't read not one of these constitutions before we went to the DMV. Texas Constitution. Oh, they said, now Texas is nasty. They said, humbly invoking the blessings of Almighty God. The people of Texas do ordain and establish this Constitution. All right, let's see. Boom, here we go. Article 1, Section 2 of the Texas Constitution. All power is inherent in the people, and all free governments are founded on their authority. On whose authority? The people, and instituted for their benefit. The faith of the people of Texas stand pledged to the preservation of a Republican form of government and subject to this limitation only. They have at all times the inalienable right to alter, reform, or abolish their government in such a manner as they may seem expedient. That's in the Texas Constitution today. Now be honest and don't complain about how the government has done all whatever to you. Did you spread that to the people of Texas and your community, your family, your job, your grocery store about what it says in the Texas Constitution? Okay, well, we got no right to complain about what the government has done to us, because this information should be making it to every jury in Texas. So we can't complain that the government did this, the government did that. I know the government's corrupt. I'm not naive. But I'm also not naive enough to believe that it's all their fault. Somebody chose convenience over personal responsibility. And now we want to complain that the system of convenience is not doing the thing that it wants us to do. See, the Amish people don't have no convenience. If they don't work, they don't eat. They said this is not about us working for somebody else. They say they have real life skills that real people pay us for. They said we can build a house in a weekend. They said they can build a house in 3 days with no electricity, no nails. I was in New York winter before last, and this dude said in rural New York, these Amish people is putting up his friend's house, and they said they'd be finished in a month. 2-story. In the winter. Okay, so don't. They say, y'all, you have the power to change this. If you're not telling the people of Texas this stuff, okay, well, it don't mean nothing. Because I say this all the time. If you're learning about the Constitution and the common law of England for me, we're all in trouble. Because I accidentally found the common law. Accidentally. On accident. Somebody stole my wallet and I stumbled on this thing called the common law of England. What? Yeah, we're in trouble. If nobody told me my entire life until I was in my 30s about the common law of England, we're all in trouble. Because all these court cases say that's the only thing they're supposed to be doing is this thing called the common law of England. Right? So yeah, don't come to me. You won't find no help here about complaining about how the government has done us wrong. I know the government has done us wrong. You don't have to come in my comment section talking about, oh, they did this, they did that. We know. All right. What else? I forgot where I was going. Yeah, don't come in here complaining, trying to make the comment section your soapbox. Go complain to the people of wherever state you're in. Show them in the law that that government's breaking the law. Okay. And if it don't work, then bring it before a jury and explain to them how the government's breaking the law. And if they don't want to listen, okay, we'll go to them Bill of Rights and you're going to find an answer in there. And may God help you. What the Declaration of Independence say? They said we appeal to the Supreme Judge of the world. They said we don't went to everybody else. Read the Declaration. They said On every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered with only repeated injury. A prince whose character is thus marked by every act which may define a tyrant and is unfit to be the ruler of a free people. They said, yada, 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 nor have we been wanting in attentions to our British brethren. We said, we spread the news to everybody. We told everybody, hey, the government's not obeying the law. Hey, the government's not obeying the law. Hey, the government's not obeying the law. Hey, guess what, guys? The government's not obeying the law. We know. We know. They said, we have warned them from time to time of attempts by their legislator to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of our immigration and settlement here. We have appealed to the native justice and magnanimity, and we have conjured them by the ties of our common kindred to disavow these usurpations. They said we did this. They said, therefore, we acquiesce in the necessity which denounces our separation. They said, we, therefore, the representatives of the United States of America and General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions. They said, we did all we knew to do. They keep saying they can write fake laws and take away our rights. Okay, we say they can't do that, and we're going to prove it. They said, we did all we could do. All right, so don't, you know what I mean? Have you exhausted every remedy? Have you paid? Have you put money together with friends and family and bought food and explained the corruption of the government to the people over a free meal? That's what Jesus did. He gave out fish and loaves, fish to 5,000 of them. And could you prove it logically? Right? They said after you've exhausted every resource. Now, I'm not going to come up missing tomorrow, but I'm just saying you got to read the Constitution. Read your state's Constitution. That's all I'm saying. All right. Oh, this is fun. What's the Super Bowl at? Oh, they ain't even started playing the football game yet, have they? Super Bowl. Oh, the Seahawks are winning. What quarter is it? Oh, they only in the first quarter, I think. I don't know. Oh no, they in the third quarter. All right. I'm gonna be on here to the game end. All right, what else? Let me see. Give me some more states. We ain't went over the common law yet. See, they normally don't let me do this on the computer, so I don't have a battery to worry about. See, when I'm on the phone, the battery runs out, and when you plug it in, it still don't, it don't do what it's supposed to do. But I'm on the computer tonight, so we can do this all night. All right, Oregon. Somebody say Oregon. Somebody mad. You skipped my state. Sorry. Join the Patreon. That's all I'm reading from is my Patreon. I buy a bunch of books. I find cases. They say the Oregon said this. Oregon said that. Okay. I compile it. I put it on the Oregon thing. They said, let me see. This is the Supreme Court of Oregon. The right of the people to be secured in their persons against unreasonable seizures shall not be violated. They're violated every day. They said, and no warrant shall be issued but upon probable cause supported by oath or affirmation. See, this is what's hilarious. This is what you should do. If you're on the Patreon and you live in Oregon, hypothetically, right, you need to go to the law dictionary and you need to look up all those words. I got 26 law dictionaries on there. Okay, and you need to create a Google document and you need to look up all those words. And I wouldn't say all 26 law dictionaries, but every other, year of those law dictionaries, you need to compile what those words mean. Okay? They said oath or affirmation. You need to know what both of those words mean. All right? You need to get up the law dictionary and look up the word oath, look up the word affirmation. You need to look up the word probable cause. You need to look up the word seizure. Let's see. Yeah, supported by oath or affirmation. Describing things to be seized, right? They said it must not be forgotten that there can be no arrest without due process of law. Okay, you need to go to the law dictionary. You need to look up the word arrest, and you need to look up the word. Well, it depends on the law dictionary, but they got a phrase called due process. You need to look up the word warrant. You need to look up the word, let's see, felony. You need to look up the word breaches of the peace, or phrase, breaches of the peace. They said it must not be forgotten. We forgot it. They said it must not be forgotten. They said this thing called the Oregon Supreme Court reports is for the people of Oregon. And they said this thing must not be forgotten, Oregon, that there can be no arrest without due process of law. They said an arrest without a warrant has never been lawful in Oregon, except those cases where public security requires it. And this has only been recognized in felonies or breaches of the peace. Okay, well, what's a felony? From the oldest dictionary to the newest dictionary, what's a felony? What's a breach of the peace? What's a warrant? They said it was ruled in an old English case, I think. It looked like a British case, that an officer had no right to arrest without a warrant after an offense had been committed, where the punishment is only a fine and imprisonment in jail. Yep. If you're on the Patreon, get a dictionary, download all of them, get a flash drive. You got a lot of homework to do. Yeah, people get mad, boy. You go on the Patreon, ain't nothing but homework assignments. Ain't nothing but 26 dictionaries. Good luck. Yeah, look up the words in all those cases. Yeah, you got to spread this stuff to the people of Oregon. They said there has been no authority cited by a defendant which would justify a man being in prison and being held there for 17 days without a commitment, warrant, or some other legal process. And they said they got that from this thing called evidence. You need to look up what that word means in all those law dictionaries. What is evidence? They said a citizen cannot be deprived of his liberty lawfully. One who interferes with another's liberty of locomotion does so at his peril. Dun, 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 dun. Oregon said this thing called the guarantee of remedy by due course of law. This guarantee dates by way of the original state constitutions in 1776 back to King John in the Magna Carta in chapter 40, that to no one we will sell, to no one we will deny or delay right or justice. No, the United States Code is not the law. You said you're from Oregon, right? Oregon is its own thing. Yeah, we can't cite the United States Code. The United States Code is not the law. Yeah, you can't be citing the United States Code. They said they can't take a legal citation of the United States Code. They said this thing called the United States Code is not the law. You from Oregon, right? You're not from the United States. Oregon is its own thing. I heard a lady say this today. She said, I don't know if Oregon's really a state because they don't have a Republican form of government. I said, what? I watched this right before I got on the live stream. They said, this is when Oregon joined the Union. They said the people of Oregon. They said, see, what does the Constitution say? The Constitution says, Article 4. Okay, they say, yada, yada, yada. Full faith and credit shall be given to each state for the public acts, records, and judicial proceedings of every other state. They said in Congress, blah, 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 blah. Okay, Section 2. No, that's not what I'm looking for. No, Section 3. They said new states. They didn't say they created states. They said new states may be admitted by Congress, not created by Congress. They said Oregon created itself. Uh-oh. Uh-oh, now we're getting into metaphysical terms. They said when God created the word, they say he did it ex nihilo. What's ex nihilo? Something out of nothing. They said new states may be admitted by Congress into this union. Okay, well, when you get to this thing called Oregon, they said the people of Oregon did. They said the feds weren't there. They said we never heard of the United States. We weren't, I'm being facetious, but they said the people of Oregon framed their constitution, and it is Republican in form and in conformity with the United States Constitution, and that they are admitted into the Union on equal footing with the original states. Okay, bet. Then you get to this thing called the Oregon Supreme Court. They said, oh yeah, bet. They said, oh, I can't read that case. But it says Article 4, Section 24 of the Oregon Constitution says that Oregon is immune from lawsuits except as it consents. Uh-oh. They said sovereign immunity became a part of Oregon's law with statehood. They said sovereign immunity originated in the rule that the English king could not be sued in his own courts. They said the immunity of a truly independent sovereign from suits in its own courts have been enjoyed as a matter of absolute right for centuries. They said this thing called sovereign immunity, the American states, was universally accepted, of the American states was universally accepted. What if someone is in both and reported? Or what does that mean? You're in Oregon, right? You live in Oregon. That's it. The laws connect to the land. That's why we have state jurisdiction, we have federal jurisdiction. They said neither Iowa nor Oregon modified their common law sovereign immunity. They said the Oregon Territory did not modify the common law. They said sovereign immunity was a part of Oregon's law at the time of statehood. They said all the laws in force in the territory of Oregon when this constitution takes effect and consistent therewith shall continue in force until altered or repealed. Oh, well, if you're dealing with the feds, then you gotta deal with the Federal Bill of Rights. That's what you got. If you got an issue with the feds, then you got to deal with the federal constitution. If the issue is not about Oregon things, well, then no, this doesn't apply. If it's about federal things, then you got to deal with the federal constitution. All right. Here we go. They said this thing called due course of law, a guarantee by way of the original state constitutions in 17th King John's Promise and Magna Carta Chapter 40. They said, all right, in another case, they said Oregon's remedy clause stems from Edward Cook's interpretation of Chapter 29 of the Magna Carta. They said, no free man shall be taken or imprisoned or be disseized of his freehold, but by the lawful judgment of his peers or by the law of the land. Again, who is Oregon? Oregon's not the government of Oregon. That's not Oregon. Oregon is the people. Somebody say Alabama. Let's go to Alabama. Alabama. Alabama got this thing called due process of law. Like nobody else has it. You got to see your state like its own thing. Your state has its own Supreme Court. It has its own treasury. They don't tell you about that either. But your state has its own everything. You hypothetically, I know this is not true. I know this is not true in practice, but hypothetically, you should never be going outside of Alabama for anything. Hypothetically, this is generalizations. Every case is specific, right? But they said they got this thing called due process in Alabama. Alabama said a property owner cannot be deprived of his property but by due course of law. This thing called law of the land or due process of law or due course of law, whether found in English charters and statutes or in our American constitutions, have the same meaning. Edward Cook says by the law of the land means by due course or process of law, which is by indictment or presentment of good and lawful men by the writ original of the common law. They said, I think these are British cases. The Alabama Supreme Court is citing British cases. They said the right of property, which right consists in the free use, enjoyment, and disposal of it without any control or diminution. Yep, I read it right. Save only by the laws of the land is one of the absolute rights inherent in every free man. I think that's a British case that they're citing in the Alabama Supreme Court. Then they cite William Blackstone. They say the absolute rights of individuals are the rights of personal security, the right of personal liberty, the right to acquire and enjoy property. They said, okay, there can, and then they got, what's his name? His name is James Kent. James Kent was one of the first American commentators. He wrote the first set of American like William Blackstone wrote the commentaries on the laws of England. Well, this guy named James Kent wrote the commentaries on American law. All right. They said there can be no property in a legal or popular sense of the term where neither the owner nor the person representing him has the power of sale and disposition. That which cannot be used and enjoyed and sold is not property. And then you read that part where they say, all right, Edward Cook says, well, you can't dispose of or deprive him of his property, but by due course of law, which means by the law of the land. What's the law of Alabama? All right. They said this thing called the common law is inherited from the Christian church. In accordance with English common law, this thing called healthcare is not found in the United States Constitution. And I always correct myself. I got to read the whole sentence. It's not found in Article 1, Section 8 of the United States Constitution. And they said, nor is such a power to be found under the general welfare provisions as it was understood by our founding fathers. So who told, see, this is why I get in trouble. Who told us to sign up for these birth certificates? Who told us to sign up for these Social Security cards? Not us. Who told our parents? Because technically, they don't have no evidence that you ever signed up for these things. They say it was assigned to you. Okay, well, assigning is a contract. If I didn't consent, you couldn't have assigned it to me. They said in another case, this thing called the common law rule is that parents have a paramount right to custody, care, nurture of their children. And this right includes the right to determine with whom their children shall associate. They say this thing called Alabama is a common law state. The common law of England shall be the rule of decisions and shall continue in force. Therefore, we continue to apply the common law. They said the authority of parents to direct the upbringing and training of their children is a principle of justice. They said the common law inherited from Britain and early American law derived from it were rooted in Christian doctrine. They said Christianity is a part of the common law of the state. They say it 3 times in the same case. And again, not in 1857, in 2011. They said, then why do I say that? Because these people look you dead in your face and say they don't do the common law no more. Oh, they got rid of that. That's only in ancient Britain. Oh, really? See, they only get away with it because we can't prove them wrong. Okay, well, you got to be able to prove them wrong. In Alabama, they're going to look you dead in your face and say they don't do the common law no more. Oh, that's old English. That's old Britain. People tell me this every day. They be in my comment section. Brother, I try to talk about the common law and they held me in contempt. Okay, but could you prove them wrong? No, I couldn't prove them wrong. Okay, well, we got to learn next time. Well, next time you shouldn't be in there, but sometimes we got to take the L. Do I talk about mens rea, actus rea, or corpus delicti? I talked about that when I first started the live stream. This is hour number 3. I read from this book all day about evidence of a crime. So I did all that in this book. And that's why that was like the first hour of this live stream. So I forgot I even talked about that today. But yeah, I did. I sure did. We talked about it. I asked y'all what states you were from, and I literally read this book. Talking about Arizona, California, all these people gave what states they were from, and I read all those cases concerning evidence of a crime. Now, mens rea, actus rea, all those things are when there is an injured party, and then that's still up to the jury. But the point to be established is they can't label something a crime just on behalf of the government. They can't just say, oh, well, the police officer handed out a citation, the prosecutor created an information, and then they gave that information for the state attorney, and then they're going to present you to the magistrate, and then there's going to be 4 groups of people versus you, and they're going to call that lawful. No, that's called unfair and a violation of the separation of powers. That's a violation of due process. Why? The Magna Carta says this. All this stuff is hilariously in the Magna Carta. They said, see, you join the Patreon, you need to look up a sheriff. Look up a sheriff in all these law dictionaries. Look up what the common law is in all these law dictionaries. You'll see as you get nearer and nearer to the new law dictionaries, they'll remove a word, they'll remove a word, they'll remove an important word. Look up the word money from the oldest dictionary to the new. I got them all labeled. I'll tell you, you know which one's the latest one. Look up the word money. You get to the latest dictionary I got, they don't say no gold and silver in there. They say metallic use. Oh, come on. You're lying. All right, so in the Magna Carta, they say this thing called the sheriff. No sheriff, constable, coroners, or other bailiffs shall hold pleas of our crown. What that mean? At common law, you'll see that in these cases. They'll say at common law, X, Y, and Z happened. Okay, well, back in the day in England, they had 2 types of courts. They had the court of common pleas, and then they had the court of the King's Bench. They called that the crown. They said that this thing called the crown is a corporation. You search on the Patreon, search the word corporation, all the posts that talk about corporations, read all of them. You'll find it in there. All right, I got books for all that stuff. All right. Well, the courts of the King's Bench were dealing with commercial matters, fake paperwork, fake contract, all that stuff, right? Okay, well, the sheriff came from the court of the King's Bench, and he didn't have permission to be bringing the people he was supposed to protect into a court of the King's Bench. All right, so he couldn't bring people into a commercial court where there was no valid commercial contract. All right. So they say in the Magna Carta, your sheriffs, your constables, your coroners, or other bailiffs are not allowed to hold pleas to the crown. A plea is where they create a case, where it's where we now get a plaintiff and a defendant. Those are done by pleas. Look up the word pleas in a law dictionary. Go on Patreon, download all these law dictionaries, and pull them up. All right. So they say in the Magna Carta, Okay, yeah, sheriff can't just be accusing people, calling it a crime, and then bringing you into a commercial court. How do you know it's a commercial court? Because there's no injured party in there. They're dealing with fake statutes. What's a statute? A statute is the custom or bylaw of a corporation. Okay, well, all corporations are commercial in some aspect, right? All that has to do with criminal law. That all goes back to this thing called the Magna Carta. So Alabama said, the Supreme Court of Alabama said this court does not look favorably. What court? The Supreme Court of Alabama does not look favorably upon an employer's seizure from an employee's bank account without providing the employee with due process. They said an individual's right to be secure in his or her property is one. See, this thing called due process just doesn't apply to the government. It applies to your jobs as well. This employee is not allowed to go beyond the boundaries of the United States Constitution or the Alabama Constitution either. See, they took this thing, whatever the name of the company, what they took them and held them against this thing called the Constitution. They say, yeah, in Alabama, we got this thing called the Bill of Rights. And one of our Bill of Rights is that you can't deprive somebody, no one, the government, nor anybody can deprive somebody of their rights, their life, liberty, or property without due process of law. Well, this thing existed before there was such thing as a Clearfield Doctrine. That's why we talking about Alabama. Alabama said, well, you don't never have to go to the Clearfield Doctrine. They said, we got this thing called the Common Law of England. They said this thing comes from this thing comes from the year 1215 before there was such thing as a Clearfield Doctrine. They said this thing comes from a thing called due process, that an individual's right to be secure in his or her property is one of the most sacred rights afforded the citizens of this country, a right of importance which can be traced back through not the Clearfield Doctrine, but the Magna Carta of the 13th century. They said colonial laws drew on the principles of the Magna Carta to protect. That this case is in 2016. This not, you know what I mean? They said the colonial laws drew on the principles of the Magna Carta to protect the liberty and property rights, that no man's goods or estate. We keep waiting on the Supreme Court to approve something. They said Alabama's got judges. Well, who are the judges in Alabama? Did you take it to them? They said these colonial laws. They said before there was such thing as Alabama, we had these laws. See, they don't remind us. Alabama was a part of this thing called Georgia. So Alabama's reaching into when Georgia was a colony. Because we don't realize that Georgia went all the way up until like certain parts of Mississippi, like right before the Mississippi River. Like we don't realize North Carolina went all the way to what is now known as Tennessee. Virginia went all the way to what is now known as Kentucky. So hypothetically, some of those court buildings never changed. They say, yeah, we still got these records from the colonial days. They said the colonial laws drew on the principles of the Magna Carta to protect liberty and property rights, that no man's goods or estate shall be taken away from him. He said the right to control one's property is a sacred right which should not be taken away. That's the Alabama Supreme Court. They said they've been doing that in 2016. And then they cite a law book. I got the law book. They said, see, this is why I love these state Supreme Court cases. They tell you everything. They said these people called the colonists intensely disliked the feudal implications of the quit rents. They said regarding them as a distasteful form of tribute. Tribute is a tax. They said they effectively evaded payment. They said only in Virginia, Maryland, and Pennsylvania were quit rents collected with any degree of success. They said nobody paid it. They said, we're not paying it. What are you talking about? We don't owe y'all. Let Maryland deal with it. Yeah, y'all pay them. Them boys was nasty back in the day. They said, we're not paying them. Pay them for what? Yeah, tell them to come see us about it. We'll be right outside. Load the muskets, boys. I'm not paying nothing. They said out of the 13 colonies, only 3 colonies paid it. They said, we're not paying it. You pay them. We're not paying them. They said only in Virginia, Maryland, and Pennsylvania were quit rents collected with any degree of success. They said the colonists stubbornly refused to accept any limitation. The Alabama Supreme Court cited this law book. I got the book. It say all this. They said the colonists stubbornly refused to accept any imitation of feudal land. Now, I'm talking about under a king, y'all, under a monarchy. They don't get on the other side of a monarchy and now they magically pay it. No. They said they stubbornly refused to accept any imitation of a feudal land tenure system and denied English dominion over land titles. In fact, if not in law, the colonists treated their land ownership as outright or allodial rather than tenurial. They said in any case, the last vestiges of the quit rent system vanished with the revolution. Okay, well, who paying it today? Why y'all paying it? I'm just being silly. This is not legal advice. They said that's what they did. They said that the last vestiges of a quit rent, they said only 3 colonies was paying them out of 13. And then they said, well, then nobody paid it at the time of the revolution. They said it vanished. They said they didn't pay property taxes up until the time of the revolution. And at the time of the revolution, it vanished. They said these things called Americans associated property rights with the time-honored guarantees of this thing called the Magna Carta in the year 1215. They said originally forced on a reluctant King John to protect the privileges and property of the nobility, the Magna Carta became a celebrated safeguard against arbitrary government. They said the colonial insistence on taxation only with the consent emanated from the Magna Carta. They said these people called the colonists, I'm being facetious, venerated the Magna Carta as their birthright as English subjects. They said as early as 1639, the Maryland Assembly declared that, did I not read it tonight? I read it yesterday. They said as early as 1639, the Maryland Assembly declared that inhabitants shall have all their rights and liberties according to the Great Charter of England. That's in the Maryland Constitution today. They're the only state constitution that I know of that explicitly states they're entitled to the common law of England. Maryland got some history, y'all. I almost moved to Maryland because I bet they got stuff in their law books that's so nasty. They said as early as 1639. That thing's in their constitution today in 2026. I did tell y'all this. Y'all don't be paying attention. They had Articles of Confederation in 1634. Go to Avalon, Yale. Type in Avalon, Yale. Articles of Confederation. Type in 1630 something. Type in 1630. Yep, what year is that? 1643. The Articles of Confederation of the United Colonies of New England. May 19th, 1643. They said the Articles of Confederation between the plantations under the government of Massachusetts, the plantations under the government of New Plymouth, and the plantations under the government of Connecticut, the government of New Haven, with the plantations in combination therewith. Article 1. They said, whereas all, this is Old English, whereas we all came into these parts of America with one and the same end and aim, namely, to advance the kingdom of our Lord Jesus Christ and to enjoy the liberties of the gospel in purity with peace. They said we already had Articles of Confederation. They said they did this to advance the kingdom of our Lord Jesus Christ and enjoy the liberties of the gospel in purity with peace. What does law book say? The law book said originally, what they said as early as 1639. That's in 1643. They said as early as 1639, the Maryland Assembly declared that inhabitants shall have all their rights and liberties according to the Great Charter in England. Watch this. I went to it yesterday. The Maryland Constitution. Article 5. Look, they said, we, the people of Maryland, grateful to Almighty God for our civil and religious liberty. In 2026, y'all, they ignore this document every day. They said, Article 5. The inhabitants of Maryland are entitled to the common law of England and the trial by jury according to the course of that law and to such benefit of the English statutes as existed on the 4th day of July, 1776, by which experience have been found applicable to their local and other circumstances and have been introduced and yada, 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 yada. What else they say? Yada, yada, yada. They say, yada, 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 the inhabitants of Maryland are also entitled to all property derived to them from or under the charter granted by His Majesty Charles I to Callias Calvert, Baron of Baltimore. They said the people of Maryland today in 2026 are supposed to have all that. There should be no corruption in Maryland today. They said this, they said as early as 1639. That they shall have all the rights and liberties according to the Great Charter of England. I got a Bible verse that says, don't tear down the monuments of your elders, or don't disregard the law of your elders, or something like that. I won't find it in time. But yeah, that's Maryland, y'all. They said the colonial laws drew on the principles of the Magna Carta to protect liberty and property rights. Again, what was the purpose of the Revolutionary War? The government was not obeying the law. They were not ensuring the rights and liberties according to the Great Charter of England. They said that's what they wanted. So you don't get on the other side of the Revolutionary War and they magically got rid of the common law. No, it's in the Maryland Constitution right now. All of the Bill of Rights come from before the year 1066. They said, accordingly, the colonial laws drew on the principles of the Magna Carta to protect liberty and property rights. In words closely resembling those of the Magna Carta, they got this thing called the Laws and Liberties of Massachusetts in 1648. Did we just read that? No, that's 1643. See, Massachusetts got nasty stuff too. So you can use all that stuff today. Let me see. Avalon's got to have it. The Laws and Liberty. Oh, that's a screenshot. I can't copy that. Somebody Google the Laws and Liberties and Liberties of Massachusetts, 1648. Yep. Laws and Liberties of Massachusetts, 1648. They got it on the Massachusetts government website right now. They say you can order a copy of it. If I lived in Massachusetts, that's my book. I'm teaching that to my kids. What are you talking about? They said it was originally published in 1641, but I guess they redid it in 1648. They say, yeah, you can get this right now. Contact the State Library of Massachusetts. This is nasty stuff, bro. It's got to be on Avalon. Let's see if Avalon has it. So you get to 2026 and you got to ask the question, well, who told you I owe you for my property? Who told you I owe you out of my labor? Who told you I owe you this? Show me. They can't show you. They won't show you. They'll say, oh, well, the statute was passed. A statute? Statute's not the law, sweetie. Avalon, Yale. Let's see. I guess I don't have it. But yeah, they said this thing called, in the words closely resembling those of the Magna Carta, the laws and liberties of Massachusetts in 1648 stated that no man's goods or estate shall be taken away from him unless it be by virtue or express law of the country. They said both Maryland and Pennsylvania enacted similar provisions protecting owners from loss or property except by due process. Is there a book like that for Virginia? I'm sure there is. You would have to go try Avalon, the Avalon Project, and go to 1607, search Virginia, and they should have everything pertaining to Virginia. Virginia. Yeah, they got the first charter of Virginia. They got the second charter of Virginia. They got the third charter of Virginia. What about Utah? Well, Utah is going to be a little newer. Let me finish reading this, and then I'll go to Utah. Okay, they say yada, yada, yada. Both Maryland and Pennsylvania enacted similar provisions protecting owners except by due process. Okay, remember, what is due process? Due process means the jury has to have given the verdict of guilty or not guilty before punishment has been prescribed. All right. So they said this guy named William Penn arranged for the publication of a commentary on the Magna Carta in 1687 and urged colonists not to give away anything of liberty and property that they at present do enjoy. Say we gave it away. They said colonists soon harbored other grievances against the Dominion. The colonists protested that according to the Magna Carta and English constitutional principles, taxes could not be levied without representation. The Massachusetts colonists had fashioned an important constitutional argument with which to defend their economic rights against the crown. There you go. Utah, then I'm getting off of here. 4 hours. 4 hours. All right, Utah. What's the law of Utah, everybody? Utah's got some nasty cases too. I don't have no law books on Utah. I have some law stuff on Utah. They said Utah was admitted into they said the people of Utah formed a constitution and state government, and they are admitted into the union on equal footing with the original states. Who formed the Utah Constitution and state government? The people of Utah did it. They did it on July 16th, 1894. All right, the Utah Supreme Court said that The Supreme Court judicially knows that when Utah was admitted into the Union, Utah owned all the lands and navigable waters within the state in its sovereign capacity. They said on Utah's admission into the Union, all the land belonged to the state in its sovereign capacity. They said the people of this state, this is the Supreme Court of Utah, said the people of this state are the constitutionally sanctioned architects of our society. They said at the state's founding, the people of Utah, at the time of our state's founding, the people of Utah were clothed with sovereign authority, and the people founded the government pursuant to the people's organic authority to govern themselves. They said the privilege of a writ of habeas corpus was transmitted into American law principally through the traditions and the common law. Yada, yada, yada. They said this thing called the new sovereign of Utah, the people. They said this thing called the habeas corpus stood on the most solid ground of sovereignty. They said Utah enjoys sovereign immunity and cannot be sued without its express consent. Who's Utah? You're Utah. They said we have neither a statute nor a constitutional provision authorizing a suit against the state. And they said in the same case that the sovereign power of this commonwealth called Utah is the people. So who can't be sued without its express consent in Utah? That's what they said. I wasn't there. They said at the close of the Revolutionary War, this is the Utah Supreme Court, at the close of the Revolutionary War, the people became sovereign. They, as citizens of the various states, succeeded to the titles and prerogatives of the crown. They said thus the states acquired all rights previously exercised by the king alone. Who are the kings of Utah? All right, I'm out of here. Try it again tomorrow. Night, night.